Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the kid. Dati mihi Anglican for his favorite podcast.
That's literally not true.
I didn't ask you to interrupt.
Is that correct?
That's literally not true.
Scratch all that. Oh, that was terrible. I apologize.
Oh man, it's tough to get going again in the morning. So what does this button do? Oh, yeah, that's what it is. Just checking. Just checking. All right, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you here. Happy Monday. Happy Monday. How was your weekend? How was your weekend? What did everybody do? Send pictures. It's good to be here. Let's see. Where did chat go? There it is. All right. Tisha, I cleaned. Always cleaning. What a weekend. What a weekend. Oh, you're tiny down here. Hang on, Kim. We need to... There we go. Bring it back. Kim R., congratulations. First in chat this morning. Again, congratulations, Kim. As punishment, we're going to sentence you to internet ownership. So it's all yours. Unless you've regifted it. I don't think you regifted it. At least I didn't see it. I wasn't paying close attention, though. So there you go. Kim, congratulations on your win. Once again, add this to your long, lengthy resume. Wonderful. All right. Honestly, how was your weekend? How was everyone's weekend? I think we have dumbbell today. What's happening today? What's happening today in the world of true crime? Obviously, Karen Reed's still going on. It'll go on for like a year. I'm just kidding. It seems to be forever. I think Darrell Brooks has jury selection in his little case. It might take a bit for jury selection. Doesn't that start today? I think it does. So I think that'll take a couple days maybe to find a jury that doesn't know about what he did in his car at the parade. Let's see. We have Chad Daybell up in Idaho. That'll be over on the Top Mark Media channel. I'm just getting that set right now. And I don't know about you guys, but I fell down a rabbit hole. Over the weekend. And it's a crazy, I would say, case, but it's not a case. It's a crazy news story. And it's not far from me. It's a couple hours from me. Place I've been to, Myrtle Beach, South Carolina. If you guys have not seen this, Micah Miller. What in the world? This story is absolutely nuts. It's nuts. We'll go into that in just a minute. It's all over the place. It's crazy. And it's like right in my backyard. So that's a little bird. Actually, somebody was posted that they think that something will happen in the Micah Miller case today, a development. I say case, but like we might find out if it's a case today. All right. We'll talk about this in just a minute about Micah Miller. But wow. I played little clips for my wife this morning, and her face, just her eyes going like, oh my goodness, something is wrong here. Something is wrong. I'm like, yeah, and that's before she even knew all the details. Anyway, let's see. Let's do birthdays. Can we do birthdays already? Has everyone filed their birthday requests appropriately yet? No more rabbit holes for me. No. I have too many things going on. Rejected juror. You're going to set some on the back burner because this one is wild. It really is. Sharon, once again, thank you so much. And on all our amazing mods. Sharon specifically does this for us every morning. It is wonderful. Huge service for me. Donna, Hannah, Tisha, Greg, Frenchie, and Dan all celebrating their special day with us today. So we're going to sing happy birthday to them. I say we, because that's all of us singing, not just me. I didn't say me. You didn't hear me say me going to sing. We said we're going to sing. We are going to sing. And you're going to sing with us. So the best thing to do right now is go ahead and warm up with me. La 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 la. There we go. Deep breaths, shoulders back, project your voice to the back of the room, blend your voice with that of your neighbors as we sing happy birthday to those on the screen, as well as Joyce. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Donna, Hannah, Tish, Greg, Frenchie, Dan, and Joyce. Happy birthday to you. Is that cheating to just fit everyone's name in one verse? Thank you, Sixfold. I can hear the echoes of your voice outside even right now. You really belted it out this morning. I appreciate that. Thank you so much. Dancers dancing. High kicks looking great as always. To everyone who's celebrating a birthday today, happy birthday. Happy birthday. If you had a special day over the weekend as well, happy birthday to you as well. So this is your special day. I realize there are a million places you could be, a million people you could be with. You've chosen to be here with us. Wow, the privilege, the pleasure. It is ours. Thank you. Thank you for letting us do that. Also, make sure you help yourself to free pancakes at Denny's. Thank you. Sharon McDonald is our wonderful birthday fairy. Yes, she is. All right, happy birthday. Have a wonderful one. And now let's talk about crime for your birthday present. That's what we're going to do. Have a happy birthday. Thank you, dancers. Looked amazing as well. The syncopation was just spot on today. All right, that's not the right word. What's the... All your kicks were in unison. That's what I was going for. There's another word out there that I can't remember. You guys will remind me. Let's see. Samantha says, oh, yes, I was deep in that this weekend. Lori and Chad 2.0, in my opinion. Oh, yeah. Okay, so let's talk just a little bit about this. And I keep wanting to say case because I think it is one, but it's not yet, at least not in the way we normally think of it. So I have to say that everything we know about this are allegations right now, but the story makes you raise your eyebrow like, hey, I've seen this story before, right? I've seen similar events that happen, and it ends up being, in other events, a murder case. A murder case where the husband may be the prime suspect. And in this particular case, we have a pastor out of South Carolina who has a fair following on social media, and had a presence on, I say had, because I believe he pulled everything down over the weekend. But he had a website where you could go online, you could like download the sermon, right? You could download the sermon for the day in case, couldn't make it to church. It's like, I'll just catch it online. And some of these sermons had little bits in there like, they made you think a little bit like, that's different. I haven't heard that before. That seems a little different. And he tended to bring up a lot of things about his personal life in the sermon, which is cool. I've seen that. I do that myself. Okay. I do that myself when I'm talking about, to people about religious stuff. I'll often share personal experiences. This pastor, shared a story that he said was from a friend. And he was describing this friend's situation with a deterioration of a marriage. And the friend happened to also be a pastor in this story. And the details were quite specific and heartfelt. And you get the feel as you're hearing the story that you get the feel that it's about him and not a friend. And basically you've got this pastor at the end in the story. The pastor in the story is saying to the church, well, the pastor is telling the story, says to his congregation, pray for me that I won't have this hate in my heart or something to that effect. And so you're like, wow, I get the feel that he is angry with his wife because things aren't going well and they're, looking at divorce. And they were, like, the pastor in the church was apparently, the paperwork had been started to file for divorce. And then all of a sudden his wife goes missing. Well, she gets found. But she gets found and he finds out about it. However that may be, I don't know the details of that. But he still goes to church and he preaches his whole Sunday, his whole thing. And he's his usual self from what it looked like to me in that sermon. And then at the very end of the sermon, he's like, oh, by the way, found out last night my wife passed, self-inflicted. Yeah, she had mental health issues. And it's just like, whoa. Like red flags are like going off and waving. And I'm like, what? And I'm digging into this a little bit, and people are digging into him as well, and finding stories about girlfriends or a girlfriend that had a similar situation with a spouse die. Her spouse was paraplegic in a wheelchair and apparently visited the pool by himself one day, and there was an accident. So it's a heavy topic first thing in the morning, but red flags are waving, alarm bells are ringing. I'm thinking there is something more to this story. And it could be exactly what it says on face value. It could be something tragic, mental health. It could be all this. But something just doesn't sit right with me. Oh my goodness. So if you guys have dug a little bit into that story, you'll see there have been protests over the weekend, justice for Micah. There have been some notable YouTubers that have been looking into this. It's all over on TikTok, and it's blown up. It's just blown up in a very short amount of time. The wife was on social media as well, so there's videos of her talking about difficulties in marriage and things like that. So yeah, we're gonna keep an eye on that. There's a little bird that says they think there's gonna be a development today. I don't know how accurate that is because I'm still trying to gauge my sources and see which ones have good information, which ones don't. But we'll keep a watch out for that, because if there's a development, I'd like to follow what's happening there, because it is just right down the road for me. It's not far at all. So that might be something we're following in the future. So if you hear anything, let me know on that front. All right. Let me recognize a couple people really quickly. Diana Beatson, 6 months, wouldn't want to be anywhere else. Love this channel. Thank you, Diana. Thank you. And congratulations on a yellow Courthouse. Ireland's Princess says, yay, 4 months. Love this channel. Happy birthday. Woohoo. She's one of the dancers. Look at that. Showing off the moves. Paula Mack, look at me. I'm orange. RA has been the best thing I've discovered on the internet. I love it here. So many friends made and great support. Paula Mack, thank you for the kind words. Part of the reason it's great is because of you. It wouldn't be the same without you. Thank you so much. Karen is here as well. Best channel on chat and YouTube. Thank you, everyone. Karen, thank you. Love to see that blue Courthouse by your name as that starts changing colors. That is beautiful. We're trying to figure out exactly where we want to go today. I think, if I remember correctly, Judge Cedric Simpson has DV cases. Is that what he does today? I think that's his Monday routine. We're looking to see if, obviously, Judge Stephanie Boyd is not going to be on first thing. I need to get Chad Daybell's case pulled up as soon as that's ready. But we're probably going to... Oh, wait. Bathroom update. I don't know if it's a law in the United States. It probably is. And so I'm probably confessing to some sort of felony here. But when you go and you buy a shower head, okay, and you think, look, I want the good one, right? I want the good shower head, the one that's, I want, when I turn it on, I want to know that the shower is on. I don't want to think, oh, it might rain today, because I want water. Okay, is that too much to ask? I want water to come out of the shower head when I turn on. When you go and you buy a shower head, even the nice one, the expensive one, that you save up for and is like beautiful and shiny and costs the most, they don't put water out. It's like it's their job to ration water, and it's a little frustrating. because you go around. I've gone through like 4 different shower heads. And like, oh, I clearly bought the crap one, right? So I'm gonna get this other one where the pictures on the box look like it's made to attach to a fire hydrant and handle that flow. And you turn it on and it's like dribble, dribble, dribble. And it's like, I'm not even sure if it's building enough pressure to use all the holes on the shower head. It's just sort of, okay. So out of frustration, I got my drill. I took my shower head and I modified it slightly. And I now have the fire hose. I have the full, all the pressure you could want, the whole water tank behind it, the town water tank driving my shower. We have scouring velocity water, if you know what that is, scouring velocity. No soap needed, just like stand in front of it, and as long as you can tolerate the pain. And the water, it is beautiful. It is beautiful. Oh my goodness. Why didn't I do this before? But a simple drill right down the middle. It's got all these little holes off to the side. It looks like, honestly, like the hole that water's supposed to go through is like that big. Can you see that? No, you can't because it's that small, right? I just drilled right down through the middle. Yeah, you can take the little ring out and it's like improves the flow by 0.2. No. I think I'm doing like 4 gallons per minute. I swear it's like downside. The downside of that, we're going to need a second water heater. Because after one shower, the hot water is gone because it drains the entire tank. Oh my goodness. So maybe I overdid it just a little bit, but it is so nice to have an indoor shower. I'm just saying that is something that I didn't know how good it was until I didn't have one. And now that it's back, I recognize how good it is. So good stuff. Darrell Brooks is going to be jury selection today. I don't think they're actually going to start trial. I don't think they'll get to that. But anyway, so that was the update. I still have the sink to install, and it's a pedestal sink. I still have a tiny, tiny drip on the back of the toilet as well. Hey, Mrs. R.A. You're live. There you go. You're not live anymore. I'm wearing my Matthew Harris shirt, by the way. It says everything I learned about law. Everything I know about law, I learned from Matthew Harris Law. Thank you very much for this, Matthew. You need a book? Is it over there? You're going to have to jump. Which one is it?
It's on the bottom shelf. Yep, never mind. It's the purple one. Thank you.
There you go. What am I, the librarian? Hey, can we turn on the AC and... I know. Can we turn on the AC and maybe set it to something lower than 80? Love you. Love you. I'll do it from here. I promise I will. All right. I've got some noise in the lower left corner. Down here. Now it's worse. There, I fixed it. It's worse. Oh. Yeah, I'll work on that. It's a lighting issue. I adjusted my lights and now it's bad. Okay. All right. Mrs. R.A., she uses the books that are on my bookshelf. Well, her bookshelf, but they're on the left hand of my studio, and you can only get them if you walk in front of the camera, basically. So she comes in and asks for specific books. I've gotten very good at reaching just about any book on the 1, 2, 3, 4, 5, 6, 7, 8 shelves that are next to me.
Because he's the guy.
All right. Yeah, jury selection for what? Yeah, it's not really going to change his outcome very much, but the process still has to be followed. So it's good. All right. Let's see. I was going to tell you a little bit more what I did over the weekend. I went to Harbor Freight, and for the low price of, I think, $12, I got one of those. It's like a Pelican knockoff brand. Do you know what Pelican is? They make those black clamshell plastic cases that protect cameras and electronics, things like that. For $12, I got one that perfectly fits my Hyperdeck, which is good because now I can ship it to Megan without worrying about it getting banged up in the mail. So we'll get that up to Megan here in a little bit. That's on the order. I also have another mic I have to send out as well. So Let's see. Where are we at? I forgot what I was saying. Anyway, showers are good. Oh, our Airbnb guests, they stayed. They loved it. Left a review. They cleaned the whole place. We had set the table out all picturesque, and they washed everything and then reset the table. Put all the towels in the washer. Did everything. They were perfect. And they didn't smoke inside, which was great. And so I was really worried, but they were wonderful. Let's see. Judy says, I just wanted to make sure you knew your shirts are on sale for $11 just for a couple more days. Judy, I have no idea how those sales work. I have no idea. I'm probably losing money with every shirt. I don't know how the pricing works. It just seems it randomly just changes, which is cool. I think it's cool. Sherry Smith, woohoo, I'm orange, love my RA family. Thank you, Sherry. Thank you. Congratulations on 12 months. Orange looks good. All right. Let's see. I am anxiously waiting for our last piece of equipment for our replay. Oh my goodness, that's going to be so good. Okay, there's Daybell's. Is that for today? That's for 5-6. Yes, okay. I can finish setting up Daybell. Okay. Got to close everything down here so it runs well. Our last piece of equipment should be coming. It's supposed to come this month. It's released this month. Did anyone break in your Airbnb? Yes. Well, they didn't break in, but they were the initial guests, the first guests. And no, we didn't give them a logbook to sign. They were pretty nice. They were here for graduation. But I think Mr. Beast's crew wants to come out and look at it, possibly today, to book it for 3 months, which is awesome. I missed all kinds of messages. Okay, hang on. Let me go back and look at the messages. Oh, my goodness. They're everywhere. Let's see. Where did we end? We got Paula Mack, 12 months. Thank you very much. Karen. We got Karen as well. Iris, member for 4 months. Oh, wait. Now me late again. I am green. Woohoo. Thank you very much, Iris. Dolphin Lover Kim, I see you there. You gifted a membership. Thank you. Thank you, Kim. Tisha S. gifted a membership as well. Rick Groover, member for 5 months, says, I've been here since the start of the Maya trial. Loyalty matters. You're still the real deal. Thank you. Ashley, member for 11 months, says, thanks, Kim. You're a good aim. No way, Kim. You hit Ashley. That is awesome. I mean, in a good way, not like a pow, like that. That would be bad. See, Sherry Smith, also member for 12 months. Thank you all for your amazing support of the channel. This would not be possible without you guys, and I thank you for that. We have, things need to happen here. Mostly I need to click the right button. Looking also into the Preston Lord murder, which is the Gilbert Goons. Doing some digging there. I think I might see if we can get some access. But I don't know exactly where the dates are. I think, someone correct me if I'm wrong, are all 7 defendants in the Gilbert Goons, are they going to be tried separately, or are any of these going to be linked up together? I'm surprised, actually, if they do them separately, but we'll see. Did you think more about my suggestion about commands? Dog Lover, I wish I could tell you, yes, I did, and I took your advice. Instead, I heard it initially, and then I thought, I need to fix the shower over the weekend, and then I thought nothing else of it, and I apologize. That's been my full focus, knowing that the Airbnb was occupied and we needed a shower that day. So that's all I did over the weekend. Let's see, Tammy says, what is it about? Gilbert Goons is basically a teenage, it's a group. It's actually got classified as a hybrid gang. Just recently, just last week, the police made that classification, which could change future charges, but probably won't change any of the charges for the existing 7. But yeah, it's a gang, and it's a group of kids that beat another kid to death. And the interesting fact here, the interesting pattern that emerges is a lot of these kids that are in this gang don't come from the environment you typically think of. when you think of a gang. You know, we watched the Airbnb trial, and we saw kids that were in a rough neighborhood with, you know, a difficult upbringing, lots of challenges, you know, the whole deck stacked against them. And here in the Gilbert Goons case, you've got kids that have basically every advantage in life, including wealthy families that are doing this, and so it's different that way, very, very different. Also, it's tragic, it's sad, and it's, you know, heartbreaking what kids will do to each other. Let's see, mod chat. I was going to check mod chat. They say that Darrell Brooks is going to go live in 2 hours. And thank you for that, Sharon. I thought the judge said it's going to take a long time to seat a jury on Friday. Are they talking about two different things? And this is the battery trial against his ex-girlfriend. Susan T, member for 2 months, says, woohoo, love it here. Thank you, Susan. Love the flower as well. Kathy Trout, member for 3 months, says, good logic's in court today. He may be on stream. He's going to be up in Karen Reed's, right? Is he following Karen Reed? Where's Good Logic? Where's Joe at? Did I save the thumbnail? I did save the thumbnail. I'll probably put it up right now. Sorry, I got a little sidetracked on that one. Just 1 second. Let's see. There's the thumbnail. Upload a thumbnail from Friday. All right, it's uploaded. Let me get Chad set up so I don't forget. Ashley has to remind me at the last minute every day, and I'm not gonna take that long this time. Hang on. Let's see, Judge Boyce, right? There he is. Bring this over onto channel 7. Shut that one down. Sorry, guys, this is hard work. My brain is thinking really hard. There we go. Share audio. Share. And Ashley, we're going to go ahead and go live now, even though it's not going to happen for a bit. There we go. As soon as it goes live, we'll make it full screen, actually, instead of just zoomed in. All right, so Top Mark Media is live with what's going to be the Chad Daybell case today. We'll follow that throughout the day as that goes on. Where do we find the sale on your shirts? I'm not finding the sale in the store. Who is it? Judy, were you the one that told me about the sale on the shirts? If you can tell me where they're at, I can point people in the right direction. And if it might be a specific shirt as well. Jen Pookie, what you're mentioning right here, this is a news story. There is not a murder investigation yet. There is a death investigation where Micah Miller her body was found in a state park in North Carolina, about 2 hours from me. Hey, there we go, just like on cue. Chad Daybell just popped up. There we go. And we're good. So her body was found. There was a self-inflicted gunshot wound. The police have not released a cause of death, but her husband has, which seems strange to me that the order goes in that order. Red Pen, I put the thumbnail up. Hopefully you saw it briefly. It's live now, so okay. I did have the updated thumbnail from the 3rd. That's what I'd saved. Oh, Judy. Okay, here we go. The fishing shirts at Sam's Club. Yes, they're like $10. Unfortunately, the size that I wear is available in all the patterns that I don't think would look good on camera. But I did. Thank you for telling me that. So it's not the shirts on my channel. I apologize for any confusion, Judy. That makes sense. But the fishing shirts, I was telling my wife about that just the other day. So maybe we can do a sale on our shirts here in the merch store here soon. Anyway, as far as the Micah Miller or the JP Miller story goes, and it's JP is the pastor, Micah was the wife who was deceased. All I can say is that this story, if you just read it and look at it on face value, the alarm bells are ringing that something's not right. And every other time I've seen this sort of fact pattern, it's been involved in a murder trial. And so it doesn't sound right. Her family says, there's more to this story than you're hearing. Yeah, we'll see. So keep your ear to the ground. Hopefully that the police will come out with something soon. Now, I realize why, if they are doing an investigation, why they would be playing their cards very close to their chest. You don't want to have a potential suspect be alerted to bits of evidence or things you're chasing and give them time to structure a story or, to spin things or prep things or dispose of evidence. So they're playing very quiet this way. Yes. Thank you, Judy. All right. Let's go back here. Debbie, the Creative Bee, says 14 months of laughs, true crime, and pickles. So very glad to be part of this community. Thank you, Debbie. I'm also very glad you're part of this community. Thank you for your creativity as well. Exclamation point B in chat will show you Debbie's channel on Etsy. She's helped us out on the channel, as well as she's shown great kindness to me as well. All right. What about the teenager Noah Pressgrove? I haven't followed that story. Clearly, finding a deceased body naked that raises flags. It raises flags, but all right. Let's see, anything else that we have going on? Darrell Brooks is 2 hours. We'll keep an eye on this one. Let me check with... Okay, that's the Gilbert Goons. I need some more info on the Gilbert Goons. That's... why do I have that way? Oh, I thought it was a computer screen. It was a still image. 1, 2, 3. Okay. I saw Gisela. I say her name wrong every time. I saw her coverage of the pastor thing, and she did a great job putting together all sorts of clips, thumbnail sketches, newspaper clippings, bits of the story. It's a wild story, if that moves forward to trial, I think that would be one, because it's so close to me, that I would definitely want to attend and be at, depending on the dates. And they're overlapping with other trials. All right. Where are we at? Let's see. Okay. Bridget Robertson. Did the landlord docket with Judge Simpson on Friday. He's not live yet this morning. Dog Lover, you're telling the story about the I heard about that case, and it's wild. It's wild as well. I will tell you, there's no shortage of crime going on. It seems to be on an upward trend. Weather Watch has had a busy spring with all the weather that's going on. Okay. All right. Just getting caught up here. By the way, does somebody have a Westlaw subscription? One of you lawyers out there? I've got a link that I need access to, but it requires Westlaw to view it, and it's frustrating because it's a government saying, "Hey, please check our policies," and their policies are posted in Westlaw, and I can't find them elsewhere. We might just need to see what it takes to get one of those. All right. Okay, daybell's set and ready to go. It is a quiet start to the Monday. We're going to watch the Gregor trial. Is that the treadmill trial, Diane? Man, I don't know who's willing to take that one. I watched just the treadmill video until I just couldn't watch anymore. I didn't even watch the whole thing through. I'm like, I just cannot do that one. Yeah, probably by searching treadmill trial is probably going to be your best bet on. Let me see if I know anybody who's doing it. As far as streamers, Court TV, but Dr. G did a video on Christopher Gregor. I don't know who's covering it as far as streamers go. I don't think they're in court today for the treadmill trial. That would explain why. Taking Monday off. Law and Crimes covering the Gregor trial. Labman, we're looking at doing a delayed catch-up, like well after the fact, on Karen Reed. Like I want them to get further ahead before we start. But I think we might start watching Karen Reed delayed. So there's, there will be spoilers all over the place, but we'll look at that. Judge Brantley. Let's see if we can pull him up real quick. Judge Brantley. Let's see what this judge is up to. It's been a while since we watched him. Let's see, he's got jury selection going on, so he must have a trial coming up. Bay County, Florida. Just getting started for the day, I think. Darrell B is not representing himself. He has a lawyer, different judge. It's a different location entirely. Darrell Brooks starts in 2 hours. We'll try to pop over there as soon as it starts.
That's where my
I'd rather go to that. I wish it's close to work with them. But all of those also have this in Charlotte.
Bleach X, yes. Darrell Brooks is back in court. This is for I think it's domestic violence against his girlfriend charge. All about the same time period as the parade incident. But he was back in court for a hearing on Friday, and then I think the trial starts today. I think it starts with jury selection.
All right, we go for the record. All right.
Are we going to address subject matter jurisdiction?
I'm sorry.
That is what it is.
Lawyer's losing his jacket. And we're buffering. What's wrong, Florida? What just happened? Did he just shut down his stream? We're covering Daybell over on the Top Mark Media channel. And it's just a live stream. Selena, you know you've been over there. Sorry, didn't see who was asking the question. Yep, they shut it down. Nice. Back to 14th Circuit and see if they've got another video up. Judge Boyd, all the way down in Texas. Let's do that one. Judge Stephanie Boyd.
Thank you. All right, you're Darren Johnson? All right, thank you.
She's doing roll call still. We made it in early.
Dario Herrera. Dario Leos Herrera.
This is Judge Boyd. She's out of
In custody, we have Valentin Saldana.
Bayer County, Texas.
Giovanni Escobedo.
San Antonio.
Ismael Games. In custody, we have April Sanchez, Luis Beltran, Alex Pardo, Michelle Flores, Jimmy Dotson, Dylan Bell, Luke Galvan, Sebastian Delgado. I think that's on the docket twice. Thank you. Joseph Balboa, custody. Torrance Knowles. Torrance Knowles. Jonathan Dash. Thank you. Daniel Ramirez.
Thank you, AZDCS.
Daniel Ramirez.
Appreciate the
Oh,
gifted
he's in
membership.
misdemeanor court. All right, is there anyone whose name was not called? Yes, what's your name? I'm sorry, what? Stand? Stand? What's your name? Repeat the first name.
Clyde.
Clyde? Last name.
Sutherland Trevino, Judge.
All right, do you have an attorney? What's your SID number? What's your case number? All right, just have a seat.
He doesn't know his case number, doesn't have an attorney.
All
I'm
right,
just here
everyone,
because they said to come to
please
court.
confirm.
Judge is already a little frustrated with him because he just
So this
mumbles.
is what ends up happening. So everybody in court has a role.
Oh, she's got
I'm the
some
judge, of
court
course.
watchers.
You have prosecutors and you have defense attorneys. The way this district attorney's office runs is similar to the way other district attorney's offices run. And usually you have different divisions for prosecutors. You have criminal trial division and you have family violence division.
We're going to try to cover Darrell
So
Brooks
over
today.
here is criminal trial division, over here is family violence. Family violence, they handle anything involving children, anything involving family, anything involving boyfriend, girlfriend, type of relationship things that way. This side, they handle everything else that's really not that. You do have what they have a civil rights division, and that division handles any cases in where police officers are alleged to be, well, police officers are the accused.
Right.
And then you have an integrity division, and the integrity division works on maybe somebody has an innocent claim. They'll say, hey, I'm actually innocent of this, or at the time I didn't receive the discovery that I'm supposed to receive. Sometimes they'll get notices of stuff like that, and they'll look over the case and see whether it should be dismissed. I think from cases, I've had cases in my court that have come back before I was even judge with the integrity units, and they'll look over them and we'll have counsel appointed to that person to see whether or not their case should be dismissed or not. Yes, yes. And sometimes it's cases involving DNA. Yes.
Morning, Judge. On Sebastian Delgado, that's just a PTD contract issue.
All right.
We submitted that this morning.
All right. Let me have the clerks come out because they are not out here for some reason. Oh, there you go. I can't see you around the screen. Attorneys, if you're ready to approach, then you need to have the clerk pull your file. Only approach the court if you confer with the state and confer with your client. All right. And which file is it?
Sebastian Delgado.
Okay.
Your Honor,
Yes.
Jonathan Dash has parked and is walking over right now.
All right. Thank you.
Your Honor, I'm gonna run to another court. I'll be right back.
Sure. All right. Sebastian Delgado. Hello. All right. How's your hand?
Way better. Thank you for asking.
All right. Well, don't rub it too much. Isn't that messing with the skin? Well, you know, you're not supposed to be scratching that. I know it's hard. I've had, well, the burn I had, I didn't get that done. I hid it from my mom. And so by that time, it was sort of like too late to do anything. All right.
Mom's watching.
All right. You need to make sure that you meet all of the deadlines that they're giving you for the PTD. Okay.
Yes, sir.
And let me see what date I'm going to give you. All right, counsel, I'm going to recall this for June 24th. Is that a good date for you?
I may be out of town, but if so, we'll get in touch.
All right. And then about that, it's a setting. If everything goes well, your case will probably be dismissed by then. So make sure you stay on top of everything so it can be dismissed by then. And counsel, if it's dismissed by then, of course, you don't need to show.
Thank you, Judge.
All right, once you sign the reset form, you're excused.
Thank you.
You're welcome. Have a good day. I'm glad you're speaking up now.
Morning, Your Honor.
Good morning. How are you doing?
Fine, thank you.
I have an intern here.
Do you really?
Yes.
Oh, good.
And thank you, John. I knew
The
the bloom.
magnolias are out.
They're in bloom. I love, it reminds me so much of home.
I took one over to Tamara
Yeah.
for old time's sake.
Okay.
I just want to make sure nobody had stolen it.
Aw, thank you so much. I appreciate it.
People around here, you know?
Yeah.
Thank you, ma'am. Judge, remember Thomas?
Yes.
And then Leticia, he referred Leticia to.
Yeah.
Well, they called me last week that they wanted to take me to dinner because they were so appreciative of what I've done for them. So we went out to eat and everything, and
That is so
they
awesome.
didn't want me to pay, but of course I paid anyway.
Yeah. Oh,
Yeah.
but yeah, so you have to meet the new
I'll
intern.
go around here in a second.
Okay. So those are the divisions, and we have some more divisions in the district attorney's office, like you do have prosecutors. This is Johnny Cisneros.
What's happening? Thanks a lot. Have a good day. Have a good day.
I would rather.
The judge loves to show off the courtroom and introduce new people to the court system, specifically interns and students, I think.
It's all a ruse from Joe Gonzalez.
You're doing pretty well, so it doesn't matter.
No, he does great. Thank you.
I'll be back to look at, I gotta look something in the water.
Oh, sure, no problem. So they have other divisions upstairs as well. But you'll be able to learn a lot. When I was in law school, I'm more the person who learns by doing. I have to, and then I can see, this is why it's this way. Because I'm telling you, the rule against perpetuity, you just, and then finally, when we take the bar exam, I'm like, oh, it's so clear now. But doing it, you learn it. We're probably going to end up having a jury trial in here on Tuesday, and they'll have the jury selection. So you'll get a chance, unless everything works out, you get a chance to see a trial from beginning to end. And so, and then the other person people tend to ignore, but they're very important, is the court reporter. So.
You could be right. I thought it was.
So they take down everything that everybody says. That's why I always tell people, please speak up. Because when you think about it,
Yeah, that's what I'm.
there are no less than
Okay, I'm sure because we'll be when sure we'll visit this week.
4 people that they usually have to take down on average. And then on the civil side, sometimes it's 6 people. And if you can imagine, everybody talks at a different speed. Some people whisper, no matter how many times you tell them to speak up, but they have to take everything down because if it's not in the record, it sort of didn't happen. And what I mean by that is when they're doing a record for an appeal, they'll try their best to like put on the headphones to listen to see if they can get that one word. And then if they can't get that one word, then it's, you can't get that one word. So, they do have a shortage of court reporters though, and they're looking for court reporters. So you know somebody who would like to be in the legal field, but they don't want to go to law school. They want to do something else. Yeah, ask them. And so it's very lucrative if that's what you want to do, and you get a chance to hear what everybody else is saying. So yeah.
Did anyone buffer just for a second?
Oh, and the other thing about the prosecutor's office.
You got like 2 seconds of
They
buffering.
have first chairs, second chairs, and third chairs in felony court. When I was in felony court, I would always tell my second chair, the only difference between me and them, they're like, what's the difference? I'm like, there's no difference. You're an attorney, you have a bar card. You know, review a case. If you have a question about a case, ask me. If I made an offer in a file and something changes and you feel like that offer should be changed and somebody comes up to you and change the offer, just have a reason for why you're doing it. Some people don't feel that way. That's the way I did it when I was starting, because you got to let them fly and spread their wings. But so Jason Garhan, that's the first chair. Jason, can you raise your hand? If you'll raise your hand. All right, that's Jason Garhan. He's the first chair. That's Daniel. He's second chair. That's Hank, third chair. Well, second chair now because he's been promoted. Congratulations. Yay. All right. And then over here, I'm still learning your name. I'm so sorry.
Margie.
Margie. I don't know why I can't remember that. Over here, we have Margie, and she's in family violence. So move about the courtroom. Right now, you have an attorney here. He's talking to one of the prosecutors, and they're probably negotiating plea offers, or maybe there's discovery that he feels he doesn't have. So step down, get in the mix. Yeah, just go up there. Yeah. You got to be bold.
Just walk up and insert yourself in the conversation. She's talking to an intern.
And then after that, I'll introduce you to probation and the advocate. Sure.
Then we left them in the back.
Oh, yeah. And then I'll introduce you to the deputies. So Jason, Hank, Daniel, he's a little bit shy. Move him into the mix. Let him see what you all are doing.
Here, it's actually
So she's taking just a few minutes before she starts calling cases.
Maria, whenever you need a break, just let me know.
Okay, yes, thank you.
Sure.
Judge gets a break right now. Just refilling a mug. All right, let me check mod chat, Samantha. Thank you.
Horrible handwriting.
I know.
I'm sorry for her.
No problem. What overtime here?
Ron, if I'd like to put something on the record, can I do that?
Okay.
Well, Judge, here's the thing. Did I tell you about my first week on the job?
No, you did not.
I was sitting in the cafeteria.
Do you have your rubber boots on?
Yeah, I do.
It's gonna get high here, I feel like.
I was sitting in the cafeteria, Judge, and I'm just minding my own business, you know? I'm a new kid on the block, you know? And one of the prosecutors for the DA's office came up to me, and he was like, "Give me your lunch money." And I was like, "Am I being bullied?" I'm like, "Is this like, am I like in middle school?" Like,
what's happening?
And he threatened me. He was like, "I'll beat you up if you don't give me your lunch money."
What?
Yes, this is true.
Get out of town.
Uh-huh. Oh yeah, right here, Judge. Look no further. And he said, "Remember the name, Hank Wilkins." And see, he was already intimidating then, but now, Judge, that he's been promoted, I find him extra intimidating.
Oh my God.
So I'm just wondering, is he staying here, Judge? Are we putting him back there with those guys?
Oh no, I think he's gonna be here.
Well, I'm a little scared, Judge. I just want to know.
And now I think he's gonna charge interest.
Try to be I've never been intimidated.
You know, on no jokes, he was my first email at the DA's office.
Oh wow.
The time you were with the conviction Tariq, they send you the emails when you first on board. He actually was for real, the first person to ever reach out to me.
Oh wow.
And like welcome me to the DA's office.
Well, and Zach is very proactive. He came down here and was like, "Hey, I want to meet you." So that's good. You know,
That's real. Yep. Hank was the first person that ever said like, "Welcome to the team."
Oh, that is so awesome.
You know
that? I just recognize talent, you know.
Oh.
He was looking in a mirror when he said, "Excuse me."
Oh, and Deputy Laura, whenever you want to take James to the back, you know.
We'll take them.
Yep.
I can't believe it. I'm caught up on my emails. And just as I say it, I get more emails.
Okay. I was there sharing about.
Vashon, can I see you for a moment?
That's where you.
Hello.
Susan Lynn, I'm trying to find rule
And Robert, we have an intern.
1 to
and you're sitting next to him.
2.1 for Arizona.
Yes.
Let me see if I can get you a link. Okay, hang on. I'm going to try to post this link. Now, this link's just for Susan. Anyone else clicks on it, they'll find out it doesn't work for them. Nope, that didn't work. That didn't work. Didn't work for me either. Let's try this again.
Yes, I think that's right.
Not sure if that worked.
And Margie, I just figured out why I couldn't remember your name. Now I'm going to know it always. But it's because I never see your name on documents.
On document?
Oh.
Yes.
It's because, yeah, I've been recently trying to sign them off and fill them in.
But
yeah,
once it
exactly.
gets to me, but now I know it. So you don't even need any documents anymore.
Sure, okay. I'll take it, yeah. You want the file or? No, I'm sorry.
And I told this.
Okay. Sorry, I got some stuff done there. All I've got is that this is Arizona policy use regarding our use of recording devices in a courtroom. Rule 122 and 122.1.
How many days on somebody has?
Hey, 80s Music Man. I have to say, I've received many songs over the weekend. I think Thomas sent me some. I got some that I think originated from 80s Music Man.
It's just easier this way.
You guys have made some great music. I cannot play them, but you made some great music. I loved listening to them.
I'll wait.
Oh, I'm the one who set cases. Yeah. All right, Jonathan Dash.
Finally, calling some cases here.
And let's see. All right, why were you late?
They told me second floor. Came to second floor, told me fourth floor.
All right, so now you know where the court is, so do not be late, okay? All right, counsel, have you received all the discovery?
I believe so, Your Honor. I still need to review to make sure that I have. This is our first setting, so I still need to go through everything.
All right, State, were you able to tender an offer?
I wrote an offer, but I don't know that's we had a chance to talk out.
No, we had, Your Honor, I wanted to, I guess, wait until I review discovery before I discuss an offer with the state.
Okay. All right. All right, we're going to recall this, and it's being recalled for June 10th. And that's going to be your plea deadline date. At that date, you're going to need to let the court know whether or not you're accepting the state's offer or whether or not you want a jury trial. Do you understand? Once I give you the reset form and you sign it, you're excused.
She excused, Your Honor?
Yes, once he signs the reset form and turns it in.
That's the intent. We're trying to cover Darrell Brooks. Doesn't start for about another 95 minutes-ish. About an hour and a half. And it might just be jury selection. We used Suno, S-U-N-O, to make some songs last week. There's some other ones out there as well, though.
Yes.
Sure.
Oh, that is so awesome.
We had a good time.
Oh, that is so
We were
good.
there 3 hours, I think.
Oh,
Yeah, we had a really good time.
that is so awesome.
It makes me feel good. And I asked them, what y'all do wondering how long was a 75-year-old guy, you know?
Yeah,
I said, we just love your character, your personality, and
that is so awesome.
so it was an honor for me to be invited by them.
Oh, but yeah, if you have a trial or something coming up, James would be willing to.
Please
work
tip
on
the
it.
camera down.
Okay,
baby.
thanks.
Okay,
Please tip it down.
awesome.
Yes, ma'am. I'm gonna tell him something in front of you.
Okay.
I'm the only one. You can look me up on the internet. In the history of undergrad and law school that made the dean's list all through undergrad and law school. Now, my name was never on it. I worked at the office and I would print them out.
Lawyers bringing all the jokes. It's going to drive me nuts with that camera pointed up at the ceiling. It's awesome, ACDCS. I'm sure you were there in support.
Oh, James.
Paging the intern, paging the intern. This is James.
Oh, so those are inmates. Sometimes people are remanded without bond, which means they're not allowed to have a bond. And then you have some people who have a bond and it's too high and they can't make the bond. So that's why they're in custody. And different colors of uniforms mean different things. So the male inmates, they can be in orange, they can be in tan or sort of like a gray color, and they can be in red. The orange color is just someone who they say is not a problem child, right? They just have like basic charge. Maybe it's theft, maybe it's a drug case. The red, they're usually in administrative segregation. Maybe they're a gang member. Maybe they've been causing issues at the jail. So that's what red means. And also sometimes they will put people in different colors or put them in segregation for different reasons. Sometimes it's mental health issues. Sometimes it's because they're gay or something of that nature. They will separate them. But then you have some people who are a member of the LGBTQ plus. I mean, I hope I didn't miss anything. They will have them in general population, but that's because they're fine with being in general population and they want to be in general population. The females, their colors are blue, which is similar to orange in the fact that it's just, they're really not going to cause any problems. They just have your standard cases. But then females can also be in red too for gang membership or they're causing issues at the jail. And sometimes they will have them, in the tan or white or gray, and those are trustees. So those are people that they get extra credit for helping at the jail. And when I say extra credit, when people are serving time at the Bexar County Jail, you either get day for day, which means if you're in there for 5 days, you only get 5 days credit. But then you have some, and usually that has to be requested by the judge saying, I want you to serve day-to-day time. I normally never do that. Then you have some people who, when you're in the jail, automatically you get 2 for 1. So that means that for every day you serve, you get credit for 2 days. And then you have people who are trustees. Trustees, they get 3 for 1. So every day they serve, it counts for 3 days. And that's because sometimes they'll take them to clean trash around the buildings. Sometimes they're painting. I don't think they do it anymore, but usually they would send them to the court to paint or something like that. Then you also have females who are in yellow. That's either solid yellow or white background with yellow stripes. That means they're pregnant. And that's
Dario?
help the deputies know, because when you're pregnant, you're not supposed to handcuff them behind their backs for medical reasons. So that's the thing. And that's their classification. Yeah. And so whenever you have a client who's being difficult with you, for absolutely no reason, sometimes clients will be difficult for you because they just want to be difficult. But other times, sometimes there may be issues and you want to look at what their classification is. And the deputy, when she gets a break, she'll show you the cards they have, because they get a card for every inmate who comes over. And on it will tell you what their classification is. Like, are they in the mental health unit? Are they in the infirmary? Because they do have nurses at the jail. Now, sometimes there are things they can't handle, so they'll send them to University Hospital, which is usually where they go if there are major medical issues. But they do medications and that type of thing at the jail as well.
Yeah.
So.
So I'm gonna talk to them. Okay.
Yes, and if you ever want to
Thank you.
a tour of the jail, just let me know.
I remember you gave me a tour.
I did.
Neat experience.
Yeah, it's like code two.
Yeah.
There you go. So you guys ready for the
I always
test?
tell people, honestly, if you want to be a prosecutor or a defense attorney or work in the criminal field, you really need to see all of it so you can make an informed decision. Like, is this my passion? Is this not my passion? Because it really has to be a passion thing. Because honestly, the solo practitioner's life, you're not going to get super wealthy. Like what you see on television where somebody gets a case and they get paid $200,000 for it on the criminal side, that's very rare. It's rare that you have somebody who's charged with capital murder and they can actually affect the attorney, because when you think about it, you have to pay the attorney. You need a mitigation expert, and that's standard for capital murder cases if they're sentenced to death penalty, even if they're not. I used to always want a mitigation person to delve deep into my client's history and talk to family members. And I talk to family members, of course, but I'm looking at it from the viewpoint of a defense attorney and how we can make all of this work. But sometimes you want somebody to look at it from the viewpoint of a mental health issue. And if somebody is guilty, how can you mitigate their punishment? I always tell people, when you do go to a jury trial, if you're a defense attorney, you should always think worst case scenario. Worst case scenario is my client is found guilty. How are we going to handle that? What witnesses are we going to call? Because once the jury finds you guilty, the only thing the jury knows about you, unless other things have come into evidence, is that you've done a bad thing. And with the jury, sometimes, even though they're not supposed to let sympathy or bias play any role in their decision, when it comes to punishment, you want some sympathy. Like, hey, here's my client. This is the hard life he had. I once had a client on the CPS side, and he ended up having his children ended up having a case on the criminal side. And I was sitting there and I went up to the defense attorney and I said, hey, you have been through a lot and you need to ask for CPS records. And maybe the state will offer something different. And once they realized everything that he'd been through, they did. He's doing great now. But yeah, so that's what you should be doing as a defense attorney. So, and being a defense attorney,
Susan, if you can, you can send it to my email. That would be
follow
fabulous.
all of the rules. Like if somebody says, hey, this is where your hand's supposed to be on the steering wheel, you turn your signal here always, and this is the number of feet. But of course, once you become a more experienced driver, the hands on the steering wheel go out the window.
There's my email right here.
Because what had happened to me in Louisiana, I had my driver's license and I went to go get it renewed. Now, mind you, I have been driving forever. I think by that time, like maybe 10 years or something like that. So I go back to get my Louisiana driver's license. They can't find me in the system anywhere that I ever had a license. I'm like, here it is right here. On the file. And do you know, they made me retake the driving test. And let me just tell you, I'm in my mind, I'm like, oh my gosh, where are my hands supposed to be on this wheel? What if I fail the driving part? Because I lost everything. And the guy tried to trick me. There were some train tracks. He's like, oh yeah, you can turn up here. And I'm like, it's not a one way. I'm not allowed to turn unless the light has changed. But it was, my heart was beating. And then he tried to joke at me and play it off when we got back to the office. And he's like, well, I've never seen anything like this before. I'm like, no. And then he told me, okay, you pass. I'm like, yeah, because I was just like, oh my gosh, I'm not going to have a driver's license. So sometimes that happens. And I would always tell people, when you come out of law school, you know more law than any attorney knows who's been practicing, because you just got it all, and law is changing. Of course, you know, the Constitution is the Constitution. Certain things are not going to change as it relates to that, but everything else about new things. Oh, just 1 second. Michelle Davis.
Hello, Judge.
Yes, where's Michelle Davis?
She's here. She's in the
All right, come forward. Oh, are you doing okay?
Yeah, a lot of health issues.
Okay. All right. Thank you for dressing appropriately for court. So
What I tried.
no, you did a good, you
Can't
did a
wear
great
these
job.
right now.
So, do you need to report by Zoom next time?
Your Honor, it would be beneficial. However, what we have, the reason why we're approaching today is because I have a motion for competency that needs to get heard. I haven't heard back from Carruthers Court.
All right. Did you file the motion?
It's file stamped and it's just waiting for
Okay. When was it filed?
about a month ago.
Okay.
With Carruthers?
Yes.
Okay, they haven't told me anything about that.
All right.
Yes.
And so, and you are here? Why are you here?
From the state.
No, I mean, okay, for
Your Honor, the prosecutor that is handling this case is unavailable, so.
Okay, because usually you're not here.
He was here to fill in. He told me a little bit about how the case is going on their end. Their paralegal is also here, double checking to make sure that I have all the evidence. However, at this point, even though they have extended an offer, I need to wait to see when
The competency.
competency comes back.
All right. Yeah, I thought you were here for Veterans Treatment Court or something.
Oh, no.
Yeah. All right. This is what we're going to
Thank you,
do.
Susan.
Because if there's a competency, it may take them a while to get it done. So we're going to call you back for July 8th. All right.
Thank you, Your Honor.
And I'll give you a reset form. And once you sign that, you are excused.
Thank you, Your Honor.
Sure. So is there any outstanding discovery? Does anyone know?
They're double checking that right now, Your Honor. I don't, it looks like they've given me everything. However, it's a very big file because it's many bank statements that need to be combed through.
All right.
Brooks
So
has a
your
lawyer
July
this time.
8th date then will be for discovery. Everyone needs to make sure that all the discovery is there by that date. And once you sign the reset form, you'll be excused.
Thank you, Your Honor.
You're welcome.
Yeah, of course.
All right, and this is the docket sheet. So what the docket sheet is, it's a link to everybody who has court today. and there's one that's produced every single day. Now, sometimes the system messes up, and that's why I always look to see if there are cases that have not been set. But everybody on there is everybody who's supposed to be in court today. And some of them are inmates. And if you look at it, let me show you. So off to the side here, right now, that means they're in jail. This means that they're on the bond. You look through it, all of them will let you know. And on the side, this is the list of attorneys. An A means they're appointed. Usually they're appointed by the system, and H means they're hired. And then if you see somebody with nothing by their name, that means that they have something happen in the system, and either they haven't been interviewed for an attorney, or either sometimes it'll say denied, which means they were interviewed for a court-appointed attorney, but the decision was made that they can afford an attorney. Yeah. Yeah. Yes. And then there is a while on the CPS side, because it's civil. Before I became an attorney, they would not give you an attorney for different proceedings. But now that's changed. So you have an attorney at a majority of all proceedings. Sometimes when it's a safety plan, where they're just trying to help you out, saying, hey, you know, clean up your house, and we'll come back and check on it. If it's clean, we won't file a legal case, but that's on the civil side. And usually you will find that your CPS cases, which are child protective service cases, sometimes those become criminal cases. Sorry. Because usually you have an allegation of physical abuse of a child, sexual abuse of a child, or maybe a child died. So even though you have the case over there, you'll have it running sort of like a companion case of a criminal side. But even though they're completely separate entities. And the key thing about civil cases and criminal cases, on the CPS side, if your client decides to take the fifth, it can be held against them. Yes. And so on the criminal side, you know, it can be held against you, but yes. And so sometimes I would have clients on the civil side, they're like, oh, I want to testify. I'm like, no, because whatever you say over here, somebody, if they're paying attention, they're just going to come over here and ask for the transcript. And then it could potentially be held against you on the criminal side. When you testify, they'll use it against you. And technically it wouldn't be hearsay because it's taken while you're under oath. But sometimes people would have to balance, do I want to fight for my child? Plus risk having a criminal case because of what I've said. And sometimes on the CPS side, they want you to admit what you've done because that shows that you accepted responsibility. Accepting responsibility is big over there because it shows that you're learning and you're internalizing what they believe you did wrong and you're making changes. But then that counts against you. Yes.
It's a double-edged sword there.
Okay. Okay. Let me see this.
Darrell Brooks starts at noon, and it's not in Boyd's Court.
Could I see the file on Lopez, please?
If he was down in Texas, but he's not.
Yeah.
He's here.
Yes, sir. Yes, sir.
Hello.
Hey, dude.
Hi. Well, we're having a contested, so.
Your Honor, I'm aware that it was set for contested. However, we did schedule a jail visit with our client, communicated the circumstances to our client, and she stated she wanted to proceed with some kind of agreement with the state.
Okay.
But she refused transport this morning, so she's not present here.
All right. So,
You don't know why it's canceled?
Deputy Laura,
Yes, Your Honor.
can you let them know at the jail that Ms. Lopez needs to be brought over?
We just need to have it signed because she refused to do herself.
All right. Do you need me to sign anything?
I need a paper saying that.
Okay.
And that's at 1:30, right, Judge?
Is there any way I
Yes.
can find out?
But I mean, if you're here, everybody's here and everybody's ready to go, we can have her brought over this morning.
Yes, ma'am. We just don't have our witness. If it is contested, we won't have him until 1 or 1:30.
All right, but he's saying that she's changed her
Yeah,
mind.
that'd be great.
That was the original understanding, Judge, and this was back on, we met with her on 4/17, and that's what she indicated to us.
All right, could you give me just the B page?
The judge is about to sign a transport order.
Sometimes you have people who are at the jail. They don't want to come over. But cases need to be heard.
She is going to be compelled to attend, even though she
Unless
refused
your
transport
client
this morning.
wants to go by Zoom.
I mean, I'm not opposed, Your Honor. It just, I haven't had any communication with her.
Well, she'll have to agree to it.
Right.
Yeah, it's probably best just to have her brought over.
Exactly, Judge. Thank you.
You're welcome.
Darrell Brooks is at noon Eastern time. Haley's comment.
Is this a student observing today, Your Honor?
Yes.
There are a couple judges I'd like to see.
Are you in law school?
Yes.
Traveling around the country.
Okay, very nice.
Yes, he's at Baylor.
Okay, very nice.
Nobody's gonna hold that against him here, though.
Maybe a little bit, Judge.
Yeah, it's not football season yet. We're okay.
I'd like to see Judge Carroll be a traveling judge. That would be awesome. From state to state.
Any force, Judge? Any forces needed?
Yes.
Any force if needed.
Let me know if there's anything else you need me to write.
The judge
All
is
right, so
flexing her pen.
They should
there.
probably have her here before the noon break.
Okay, sure.
Right.
What time is the new break?
At noon.
Well, we break at noon,
Noon?
but
Okay.
they'll probably.
What color is George
It
Washington's white
depends on
horse?
how long it's
White.
going to take them to force her out of the cell. And
Okay.
so if you leave your cell number, we can text you.
Absolutely, Judge. I will. Be happy to.
Okay, awesome.
Thank you.
You're welcome.
Yeah, we'll try to get something.
Joe Hernandez. Hi.
Hi, Judge. This was the case that I had asked to be added on to the docket. He is on the docket, but I'm being told he was canceled. I don't know why. I was just wondering.
Oh, because they said that your PSI was scheduled for June 13th.
Right. But this was a case that I spoke to you about where when I pled him, Judge Angelini busted the plea. And I wanted to see if I could withdraw the plea and start over and possibly get clearer eyes on this.
All right, because I'm looking at Joe Hernandez's file. and
Clear
it
eyes.
says
Different judge.
Punishment to be assessed at 4 years in the prison and the state is silent.
We originally had a 10-year deferred offer. Judge Angelini busted that. He was very nervous, and so we went ahead and did that because I knew that would at least get me a PSI and push it out so I could then speak with you.
All right.
She's shopping judges.
So Deputy Laura, is it possible to have him brought or no?
I'm not sure if why he was canceled, but.
I think it was
Because
canceled.
it was because it had the June 13th date on it.
I mean, if not today, tomorrow, I'm here.
What is easiest for you? All right,
Okay.
tomorrow.
Okay, thank you, Judge.
Sure.
All right.
That's good stuff, huh, Big Greg? Yeah, Lacey, it's going to be a completely different experience. He is being friendly. He's
So
in a
Vashawn,
wheelchair
on that
still.
one, they're going to withdraw their
compliant.
plea and do a new plea agreement, I'm assuming. All right.
He has an attorney now.
Okay. All right. Thank you.
Are we gonna address subject matter jurisdiction?
Yep.
When are we gonna break for lunch, Judge?
So I'm trying to calculate if the Karen Reed trial takes 8 weeks. When should we start watching it so we can skip ahead and fast forward through the boring parts and just get the highlights? Beep, beep, beep. Yep. I think we're just on jury selection today. I'm not sure what we'll get to see, if anything. So we'll see how this goes. Daybell just started over on Top Mark Media. Just let me give you a thumbs up if the audio is good over there. It looks like I'm seeing bars. I'm seeing audio levels here, so I think we're good. So with a trial that goes 8 weeks, it can be painfully slow at times. Not every day you have, testimony that's gripping, that's riveting, that's a new detail dropped. A lot of times it can be just monotonous nearly. And if we follow the Karen Reed trial, it will be delayed. It wouldn't be taking the live sentencing or anything like live verdict. And probably just hit the highlights. Probably halfway. I want to see the judge. I want to see Judge Boyd's reaction when they haul this girl in from the jail who refused transport.
I don't want to be different, but it's really, by the time I approach it, it's for 15 hours. 7 a.m. It's the whole. You might tell me.
Yeah, but we've all been in college and we have different questions.
It's a very quiet day in court for Judge Boyd.
Yes.
Two things. First, I apologize. I wouldn't have given you the flower if I'd known I was going to be coming here to see you on business.
Oh, no problem.
Second,
I love flowers.
this gentleman did not show up in March. I was hired after that date, so I didn't realize he'd already muddied the water here in the court.
So is he in custody?
He is not in custody. What I want to do is get the bond set so he can go to a bail bondsman, get the bond money, the paperwork, and then show up over at satellite office.
All right, so then here's the issue, because I need to see him
Okay.
in order to do it. But if you take this to Judge Nahara, he'll take care of it.
No. Okay.
Yeah, and he's in the basement, I believe.
I know he is.
Okay.
And I will take that with me.
I'd like to have your court in the basement.
Thank you, Your Honor.
You're welcome.
Rose, what normally happens when they compel a inmate to jail is that they get confined to a wheelchair, and they're brought in that way. And
yes,
depending on how combative they are, like if they're
is,
trying to
here.
bite and spit at people, they might also have some sort of restraints or spit guards
Who's here on Dylan Bell?
fastened. But they can literally be bound and gagged. And brought
Dylan
into court
Christopher Bell?
in some states.
Alex Joe Prada?
Good judge.
Okay. And then this is Robert Porter. He's a good attorney to follow around.
Let's see what color of orange. You guys remember from your test or
All
from
right.
a quiz?
So what is happening with this case?
What does the orange tell
Where
us
are we
about this
on
inmate?
discovery?
I believe I have all the discovery, at least what the state has tendered to me. I need to go over it with Mr. Pardo. And he did already extend an offer. We rejected it at this time.
Ooh, going to trial.
I'm so sorry. Just one moment.
You see that knowing look that the judge just gave the counsel? They gave us an offer and we rejected it at this time, which is like my client, the idiot, had a sweet deal handed to him by the
When
state.
contractors. Yeah, it is. All right, so sir, how old are you?
I'm 28.
All right, so I'm gonna set this for plea deadline dates.
Orange is
And I'll
just
set
regular
it
inmate,
for
no
June
problems.
24th, is that a good date for you, counsel?
That's fine, Judge.
All right, so we're gonna come back on June 24th. On June 24th, that's the time where you say, yes, I'm accepting the state's offer, you all negotiate on something else. You understand?
Yes, ma'am.
All right, any questions about anything?
No.
Bond reduction?
Yeah.
Yes, once he files the motion, we'll hear it, okay? All right, thank you. All right, Deputy Laura Pardo, Alex Joe can go back.
This guy wants to approach. That's a tall man right there.
Oh, okay. I'll type it. Thank you.
Get rid of basement
Yes.
judge. Rita, welcome. You're a lurker. It's all right. We love that you're here. Thank you.
And everyone, just give me a moment.
Just finishing this last level of Minecraft. Or Minesweeper. What do you think she's playing? Or wait, is that Wordle? She's doing Wordle?
Okay.
Candy Crush is like crack for your phone. Ask me how I know. Ask me how I know. I'm re-downloading Candy Crush to my phone. Temporarily.
I can ask you a question. I would have to ask about
It's loading. Hang on. This might not be very impressive anymore, but okay.
Dylan Bell. Is the attorney here for Dylan Bell? And where is Dylan Bell? All right, come down, please.
Here we go. This is how I know.
All right, where are we on this case with discovery?
I believe we have everything. I believe we're waiting on the criminal history. We're not on him before an offer is made.
Judge, there wasn't
We're on 1130.
Investigator who was how at vital statistics, he said that you should be able to get that done.
I need to delete the game.
Okay. All right, we're coming back on June 13th. Is that enough time for you to have everything? And I'm sorry, not June 13th, May 13th.
Yes, Judge.
Is that enough time for you? Yes.
And Judge, I have a preferential setting in Guadalupe County for a 5-year-old custody case
Okay.
that's going. I'm fine if it's set on Friday, if we think we can, I don't know.
All right, can we bring it back on the 9th?
That should be
On the 9th is Thursday?
Yes.
Yeah, that should work.
All right, so we'll
That
come back
works.
on June 9th. On June 9th, the state will tender an offer.
Or June 9th or May 9th?
I'm sorry, why do I keep saying June? Yeah, it's May 9th.
Okay, okay.
Yeah.
So I'll see you in a few days. Fine, no problem.
Just have a seat.
There we go. It's gone. Matthew. Love this shirt. Yes, it says Matthew Harris Law on it. And something about everything I know about law, I learned from Matthew Harris Law. It's a great shirt. I think you can get your own. I think Matthew sells these, which was wonderful. Good. They adjusted the camera a little bit, tipped it down. Wish they'd do a little further, but.
Thanks, you.
Might jump over to Judge Cedric Simpson, who just started small claims court. Pull up Judge Boyd here. Good old Cedric Simpson over here. What does it mean when the young man was in red compared to orange? Okay, so the red means that we have a problem inmate. Could be that there's gang affiliation. Could be that they're causing problems at the jail. DB starts in 1 hour, 55 minutes now, Tammy. So Mr. Daybell is in court as well. That's going on. If you want to watch this one, it's over on the Top Mark Media
Your
channel.
Honor, at this time I have no more questions for the witness.
All right, thank you.
Mr. Pryor's about to cross. Okay, anyway. Dan, you're on level 14,463 on Candy Crush. Dan, you may have a problem. You need an intervention. He was wearing red.
All right, getting the order for you. I'm just waiting for it to come forward.
Thank you so much.
Right, here's this. So in there, you have the docket sheet, what you have in your hand, that's the docket sheet. And that's where I write down what happened on that specific date. Yeah. And then in there, supposed to be every motion that people file. And you'll find the indictment in there. Have you ever seen an indictment before? Oh, let me show it to you. Yeah. And sometimes you have an attorney who's just a plea is different from the attorney for the motion to revoke. So this is the indictment. And it's supposed to, the indictment is supposed to tell the police what they're charged with so they can prepare the trial. So you just can have that one, two, three, and then every indictment here. Things that need to be done that occurred in Bear County, because the crime didn't happen in Bear County, that it shouldn't be here, it should be in Bear County. It happened.
We're gonna hop to another court here.
Next, do we have any discovery issues?
You do not, Your Honor.
And next question, do we have any motions to address?
No, Your Honor.
All right, so now let me find out, when is this case set for trial?
The 21st.
The 21st of May?
Correct.
Okay.
It's a 3-day.
And we are scheduled for a 3-day trial. All right. Let's go ahead and start with the people. Anything I need to know about Mr. Denhoughton?
No, Your Honor, the people plan to be ready for trial on that day.
All right, Mr. Champion, anything else?
No, Your Honor.
Matthew, this is why I come to you for advice. This is
in case I haven't talked to you about it before. We are going to need 3 panels of jurors, and
sorry, I had some background noise going on there.
Counsel,
Josh, thanks for the tip on this court.
Voir dire, the court will still, the court will allow voir dire by counsel. However, we need to be cognizant of our time. When I say that, I'm not trying to dissuade you from viable issues during voir dire to raise, but we just need to be very considerate of our time. So I will limit voir dire, the general voir dire, first 13 to 15 minutes. It might be a little bit flexible, but I think 15 or 20 minutes is fine. If you need to, obviously I recognize the nature of the offense, and I also recognize that people might have potential jurors might have experience with this if we need to do individual voir dire. Let's make sure we keep that open in our mind, so if we need to, we can take a brief break and handle people efficiently and effectively. All right, and each side will have 12 peremptories, as we know.
Each side has 12 peremptories. That's a court term.
Please get to me your requests for jury instructions. Let's say by next Monday, the end of the day on Monday. As you know, I don't often have a deadline for, I'm not too strict. I'll allow rules, but we're going to have potentially some complex instructions here. So I'd really like to make sure we get those ironed out ahead of time.
I'll have those for the court.
Great. Anything else, Mr. Denhoughton?
No, I'll have those as part of it.
All right, good. And I'll note here that we don't have any bond issues, pretrial release issues. So Mr. Grant, I just remind you to continue being compliant with your bond conditions. Make sure you guys have exchanged all the information that you need for your experts and so forth. All right. All right. If you could maybe give me an idea, at least the people, a list of witnesses, at least in order. I know I've got your witness list here in the file, just to kind of give me an idea of which witnesses we need to cover.
And maybe also with the instructions that I propose, giving a reduced witness list. As the court will recall, there was a motion, some witnesses, I don't think we did that. So that'll be, I think would make, not any additions, but a subtraction from some. I think it'll make it easier for all the parties. Right?
So let's do this. If you have an amended witness list that's reducing, not adding, have it to me on Monday next week. At the same time, you get me your final instructions.
Thank you.
Sound good, Mr. Champion?
It does, Your Honor. I anticipate we'll be able to try this in 2 days, Your Honor.
I think so. With the what I recall, the reduction of witnesses being, we should be able to get it in a reasonable amount of time. Yeah. All right. I can't think of any other issues, so we. All right. Thank you very much. We're adjourned.
That was quick.
All right.
Next up,
we're gonna next take up the file of people in the state of Michigan versus. Well, hold on. Do we have Mr. Granger?
No, this is Mr. Shaney, Your Honor, but I do need to speak with Mr. Denhoughton about this case. We've been exchanging communications regarding the final resolution.
Okay, let's go ahead and we'll leave Mr. Is it Shane or Shaney? Sheen. Sorry, Sheen. Thank you, sir. We'll leave Mr. Sheen right there, and let's see if we can take care of Miss Longoria's file and get her out of here. Not that we don't enjoy having her present. We're going to take up this case, which is people of the state of Michigan versus Carrie Mitchell Granger, file 24-3490. FH, you may be seated. Appearances from counsel.
Thank you, Your Honor. David Denhoughton on behalf of the people.
Look at that
Attorney
stack of
Diane
files.
Longoria on behalf of Carrie Granger.
You've already recognized that Mr. Granger is here. I think I was told earlier that there is a pretrial agreement. Mr. Denhoughton, the floor is yours.
Yes, Your Honor. Thank you. The people have made a plea offer to the defendant through counsel that we believe is going to be accepted. That plea offer is that the defendant will plead guilty to count 3. That's the domestic violence charge, and an added count 4, which is essentially an attempt of count 2. So it'd be attempted interference with an electronic communication device. As part of this agreement, those are 2 separate misdemeanors, but as part of this agreement, the parties agree that a PSI report will be prepared, and there is no Killebrew agreement in this file, but the people have agreed from an advocacy standpoint that we will be asking for probation and not upfront jail.
Okay. Ms. Longoria, is that a complete and accurate statement of the pretrial agreement?
With one caveat, there's no contest for you. Would that be accepted as well?
Oh, that would be fine. No contest is fine.
All right. Mr. Hold on.
And may I approach, Your Honor?
Yeah, you may. Go ahead.
He has signed an advice of right. Well, normally it would be a felony since he pled to misdemeanors. It is the misdemeanor advice of right form. And I do have the report, the second supplement of incident number 24-000208-157. I believe the first 2 pages of that will set the factual basis.
We're going to place an exhibit sticker on this document that has been tendered to me by Ms. Longoria. Thank you. All right. Mr. Denon, does the defendant have any prior criminal history of any kind?
Does not appear that he has any prior criminal history.
Thank you. All right, Mr. Granger, have you heard what the attorneys and I have just discussed?
Yes.
Is that how you wish to resolve today's case?
Yes, Your Honor.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. All right, Mr. Granger, you are currently charged today on a piece of paper called a felony information. That felony information charges you with 3 offenses. Count 1 is a charge of assault with intent to do great bodily harm, less than murder or by strangulation. That is a felony punishable by up to 10 years and or up to $5,000. I'm told that count will be dismissed. Count 2 is interfering with electronic communication device, which is a felony punishable by up to 2 years and or up to $1,000. I'm told that charge will also be dismissed. However, I'm told that you're going to plead no contest to an added count 4 of attempted interfering with electronic communication device, which is a misdemeanor punishable by up to 1 year and or up to $1,000. You are also charged in count 3 with the offense of domestic violence, which is a misdemeanor punishable by up to 93 days and or up to $500. And again, I'm told you'll plead guilty to that account. Is that what you understood so far?
Yes, Your Honor.
Now, there is another term or condition that the people will not agree that your sentence would only be probation, but they will only argue for probation and fines and costs. Is that what you understood?
Yes, Your Honor.
So do you understand that if we came here to court and I sentenced you to some period of jail, whatever it is, let's just use the number 30 days as a random example, you would not have the right to withdraw your plea. You would have to serve that period of time. Do you understand?
Yes, Your Honor.
All right. Now, I'm told that you're going to be entering a plea of no contest. A plea of no contest has the same impact as a guilty plea. However, instead of requiring you to recite a factual basis for the taking of the plea, I'm going to look at something else, such as a police report, such as the police report your counsel handed you. Do you understand?
Yes, Your Honor.
The court can only accept a no contest plea in a couple of particular instances. One, if the person was so intoxicated or for some other reason doesn't have any recollection of the event, but admits that he did something, or the other is that there's potential civil liability, which means you could be sued for any injuries caused. I would suspect this is that later type.
That is correct, Your Honor. It's for civil liability, not only for that instance, but as well as there is a current custody arrangement.
And CPS involvement as well.
Thank you. So, do you understand that, sir?
Yes, Your Honor.
Looking back here at January 27th of this year, were you on probation or parole anywhere?
No, Your Honor.
Were you on bond pending any felony charges anywhere?
No, Your Honor.
Now, by entering a plea of no contest, you'll not have a trial of any kind. Does that make sense?
Yes, Your Honor.
Now, I'm holding up right now what says an advice of rights, and it was presented to me by your counsel. Is this your signature at the bottom?
Yes, Your Honor.
Did you read through these rights before signing?
No, Your Honor.
Okay, well, we got to go over them then. It's okay. Don't worry about it.
Nope, I just
She went
signed.
over them with me,
All
but
right.
I didn't personally read through.
Do you understand them?
Yes, Your Honor.
And are you willing to waive those rights?
Yes, Your Honor.
And additionally, any appeal as to the conviction sentence pursuant to the pretrial agreement will be by filing what's called an application for leave to appeal and not a claim of appeal by right. Furthermore, by pleading guilty, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, if your plea is accepted, you will be given up the right to claim that the plea was a result of any promises, threats, or inducements not told to the court today on the record, or the plea was not of your own free choice. Sir, are you entering this plea of your own free choice?
Yes.
Has anyone made any other promises, threats, or inducements to force or compel you to plead guilty that I have not yet heard about today?
No, Your Honor.
Now, Ms. Longoria has probably done a great job discussing with you potential sentencing, try to give you an idea or estimate as to what she thinks the court may sentence you to. My question for you is, however, has anyone made any promises as to exactly what the sentence would be?
No.
Knowing all that, do you still wish under the pleas of no contest as we described earlier? Is that a yes?
Yes.
All right. As to count 3, domestic violence, how do you plead?
Guilty. No contest.
No contest.
As to
Guilty.
added count
No
4,
contest.
attempted interfering with electronic communication device, how do you plead?
No contest.
All right, so I have now before me what is People's Exhibit number 1. Again, for the record, is the Missaukee County Sheriff Report for incident number 24-208-157. Mr. Denhouten, are you asking the court to accept this?
Respectfully, yes, Your Honor.
Thank you. Ms. Longoria?
Yes, Your Honor.
Thank you.
Court's reading the police record briefly. He had one job. He just had to say no contest, and he's like, guilty.
The court hereby admits People's Exhibit number 1. Again, it is an incident report. It does appear to have some supplements attached to it.
No contest.
The court makes a note that it does cover the reference date of January 27th, 2024, and that it had an address in Falmouth, which the court acknowledges is Clam Union Township, and that's here in Missaukee County. And I make the finding that there's reference here that the defendant and victim,
so he does have subject matter jurisdiction.
At least at that period, I'm sorry, did and do have a child in common, and they resided at an address in Falmouth in Clam Lake Township. One moment.
Yeah, no contest is basically the same as a guilty plea, only you're not admitting guilt. You're not admitting guilt. You're basically saying that I recognize the state has enough evidence that they could convict me on these charges, but I'm not admitting guilt. And so it's a small difference, but the penalty is going to be virtually the same as if you said guilty.
For the record, I don't consent to that name.
Uh-oh. Judge doesn't like something he sees.
Mr. Denhouten, do you believe that you should not require the court to accept a guilty plea and will allow it to accept a no contest plea?
I do, Your Honor.
Ms. Longoria, do you agree?
I do, Your Honor.
Mr. Denhouten, do you believe? Sorry. Thought I called you by the wrong name a minute ago. Disregard. Mr. Denhouten, do you believe this People's Exhibit number 1 satisfies the elements for the taking of the plea as to the 2 counts?
I do, Your Honor.
Ms. Longoria, do you agree?
Yes, Your Honor.
Mr. Denhouten, are you aware of any other promises, threats, inducements?
No, Your Honor.
Ms. Longoria?
No, Your Honor.
And Mr. Denhouten, do you believe the court is in compliance with Michigan Oral 6.302?
I do, Your Honor.
Ms. Longoria?
The court has, Your Honor.
Thank you. The court finds the defendant's plea is made freely, knowingly, and voluntarily. The court further finds that the interest of justice based upon potential civil liability allows the court to accept a no contest plea. The court further finds that the information contained in People's Exhibit number 1 that has been admitted into evidence satisfies the elements for counts 3 and added count 4. Therefore, the defendant is found guilty of count 3 and added count 4. The case will now be set for sentencing. That sentencing will typically take place in about 4 to 5 weeks. Between now and then, the court is going to order the Michigan Department of Corrections, also known as the Probation and Parole Office, to prepare a pre-sentence investigation report. This report will include a description of the offense, description of the pretrial agreement, any statements, information the defendant makes while in preparing this report, as well as information from the victim if she chooses to make any statements. It will also include a recommendation as a sentence. Please keep in mind it is merely a recommendation, as it is the court alone that determines the sentence.
So let me tell you about an Alfred plea
Granger,
versus a no contest.
We sending them upstairs?
They're similar but different.
Or did you give a packet?
Alfred plea, you're pleading guilty, but you say I'm innocent.
No, I know.
No contest.
All right, we're going
You're
to
accepting the punishment, but you're not admitting guilt.
Someone from that office is here. They're going to give you a packet. You're going to follow instructions to complete the packet. You'll turn it back into their office. They will schedule an interview. You have the right to have your counsel present during that interview. You will also, your counsel will receive a copy of this report prior to coming back to court, and I know we'll go over it with you. Each side has the right to come back to this court and request corrections or make objections to the information contained therein, as we must make sure that it is complete and accurate before the court faces a sentence on that information. Excuse me.
Bless you.
Any objection to continuation of bond, Mr. Denham? All right, Mr. Ranger, your bond remains effective. You must make sure you're compliant with those terms or conditions of bond. Things like that, and things such as prior probations or prior probation violations also go a long ways with the court. Now, I'm told that you don't have any prior convictions, which means you wouldn't have any prior probations, which means you wouldn't have any prior probation violations, which means if you want to get the benefit, while I make no promises as to exactly what the sentence will be or what the court will do, if you want to get the benefit of the deal that you've arranged with the prosecutor, you want to make sure that you remain compliant. Does that make sense, sir?
Yes, Your Honor.
All right, thank you. We're adjourned.
Thank you, Your Honor.
Ms. Longoria, your copy of your exhibit.
Thank you, Your Honor.
Okay, so now that he's done, an Alfred plea and a no contest plea are very similar. The Alfred plea, you're pleading guilty while still maintaining and saying I'm innocent. In a no contest plea, you're accepting punishment, but you're not admitting guilt. So this guy messed it up a little bit because he said guilty. Wait, no contest.
Is he here?
He is, Your Honor, and that is
So it
going to be
defeats the
set
purpose
for
of the plea.
final resolution that we need some time with that.
One moment here, just let me find that file. The court takes up next the case of Pickles, State of Michigan versus Jacob James Westhorpe, file 24-3491FH. The court recognizes Mr. David Denhout, the Sauk County Prosecutor, Mr. Robert Champion for the defendant, as well as the defendant. We're here today only for a pretrial conference. Again, before coming on the record, Mr. Champion mentioned to me that we're just going to set it for a final pretrial. Is that correct, sir?
That is correct, Your Honor.
Any motions or discovery issues?
There is not, Your Honor.
And any objection to continuation of bond?
No, Your Honor.
All right. Mr. Westhorpe, make sure that you continue to comply with your terms or conditions of bond. I see that you've only been on bond to this court for maybe 3 weeks now. Please note that, and I assume since I haven't heard anything about you, you must be compliant. But again, any testing that I give for controlled substances is purely random. So it's not limited to 4 times a month that sometimes the district court does. Just make sure you're compliant with your terms and conditions of bond. You understand?
Yes, sir, Your Honor.
All right, thank you very much. We're adjourned. All right, that completes our docket up through 10:15. Let's see if we can catch back up here a little bit. And, oh, no, we're not. We're an hour behind. Never mind. Let's take a look at the file of Donald People versus Donald Sheen.
This gentleman on the right. There he
This
is.
is file number 24-3478-FH. Court recognizes here that Mr. Sheen is now seated at defense counsel, and present today is Mr. Robert Champion, the defense attorney representing Mr. Sheen, and Mr. David Denhout, the Sauk County Prosecutor. We are here today on the record to conduct a final pretrial conference, as this case is one of those set for trial coming up on May 21st. Now that I've done all the talking for everybody, let's see if the council can tell me what we're doing. Yes, sir.
We're looking at it.
Darrell Brooks starts in 30
We're very
minutes.
close to having a resolution, but we need a little bit more time on this case.
All right, so I know that we are currently set for trial on May 21st, but we already know that we have a much older case that's going to proceed to trial, which we've already covered on the record today. We'll go ahead and technically keep it on the trial date for May 21st. However, we know that it's not going to go to trial, and we'll just set it for another final pre-trial and see if the council are able to resolve it, or the parties are able to resolve the case. Of course, the court does not make any statement as to a finding of guilt, but just notes that for the record. Anything else today, Mr. Denham?
No, Your Honor.
Anything else today, Mr. Champion?
Row. I love it. Only in this community. I think any other community, people are like, oh, man. But you're like, I got a jury summons. Woohoo. This is exciting. Is it grand jury or just a local court? Mr. Brooks has an attorney for this trial, and he's been behaved, although he has been in a wheelchair at virtually every appearance.
See if we can take care of the file of People versus Jeremy Blake Clark. This is 24-3471 FH. Appearances, please.
The wheelchair is for confinement. It's not for a medical issue.
Appearing on behalf of Mr. Clark, who's standing to my left, Your Honor.
Thank you. We're here today for the final, no.
Yeah,
Yes. Somebody just checked the wrong block on that form. We're here today for a final pretrial conference in this case. What are we doing today, Mr.
We do have a resolution, Your Honor.
All right, Mr. Rickster, why don't you tell me what that is?
Well, we do have a resolution, Your Honor. It is quite complex. I don't know.
There's only one charge. I don't know how complex it could be, but let's see what we got.
My understanding is he is going to plead no contest to a child abuse 3rd degree. With that, we have 3 rather large reports that would have to be used. We did try to sum it up to be able to get the court to understand where all this stuff would be, where they could find it. And then there would be conditions of restitution, although still in progress, the defendant would agree to.
Let's start off first. So first point is the defendant's going to plead no contest to an added count 2 for child abuse in the 3rd degree, which is a felony pursuant to MCL 750.136
B4?
B6, which is a felony punishable by up to 5 years.
2 years.
What's that?
I believe it's 2 years.
Well, I'm sorry. So here's the, well, I could probably determine that now because the defendant doesn't have any priors. It would go up if he had priors. So it's actually a Class G felony punishable by up to 2 years. All right. What's the fine?
Serious charge.
Let's take a look.
They're just hitting the books.
What's the fines and costs? All right. All right. So besides that, then dismissal obviously of count 1, there are some other terms. So let's go over those. You said restitution
is still in progress. As of right now, the defendant agrees to pay the $11,056 to Samantha England.
$11,056.
$11,056. There's still medical expenses that are ongoing, but for right now, that's where we have it. You guys agree to having part of the probation, no unsupervised contact with children under the age of 5.
All right.
People might argue differently later on, but that was what was agreed to. And in the meantime, there's a current DHHS case going on also, and it's just agreed that if between now and time of sentencing, there is a DHHS case plan that is created, that this would become terms of his probation as well.
Anything else?
No, those were the terms that would be agreed on. The rest can be argued. My understanding for a no contest plea basis is going to be due to alcohol and civil liability.
Okay. Mr. Champion, is that a complete and accurate statement?
It is, Your Honor. We do agree that restitution is matter. There may be a question of exactly how much after insurance pays for the things, but we do agree to it.
Mr. Rickson, do you have a copy of that exhibit that I need to look at?
That's where it gets complex, Your Honor. We have 3 separate exhibits.
Do you have, did you say you highlighted some information?
I did highlight some information for the court to try to be able to get it more concise.
All right, let's go ahead and label those as People's Exhibits 1, 2, and 3 over here with the court clerk. I'm sorry, the court reporter. Mr. Clark, I'm going to turn to you now. Have you heard what the attorneys have just, you may remain seated. Have you heard what the attorneys have described to me as a pretrial agreement in this case?
Yes.
Is that how you wish to resolve today's file?
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. All right, Mr. Clark, were you on probation or parole anywhere on or about November 15th, 2023?
No, Your Honor.
Were you on bond pending any felony charges anywhere?
No, Your Honor.
You are currently charged on a piece of paper called the felony information. It charges you with a single count. That count is child abuse in the second degree. That is a felony punishable by up to 10 years. I'm told today that that count will be dismissed if you plead no contest to an added count 2 of child abuse in the third degree, which is a felony punishable by up to 2 years. So far, is that what you understood?
Yes, Your Honor.
And I may have said the word guilty, but what I meant to say is you're pleading no contest. A plea of no contest has the same impact as a guilty plea. The difference is, instead of you requiring to admit on the record in court as to the facts, I'm going to look at something else to find you guilty, such as a police report, which Mr. Ringstrom is over there busily preparing. Do you understand?
Yes, Your Honor.
The court can accept the no contest plea in a couple certain circumstances, and one of them is where there's potential civil liability or other actions that could be taken against you, and therefore compelling you to state a factual basis is unnecessary. Do you understand?
Yes, Your Honor.
Now, there are a couple other terms or conditions to this agreement. You agree that you will pay restitution to the victim in this case, and at least right now, that amount of restitution to which you would be agreeing is $1,056. 11,000, sorry, and $56. Do you understand?
Yes, Your Honor.
And
I think
apparently
he's-
that could increase, but the parties are working that out.
He's
You
confined in a wheelchair for safety
Additionally,
reasons.
well, you don't see too many agreements that deal with a condition of probation. If there is a period of probation, which presumably there would be based upon the nature of this offense and the maximum punishment, that you would agree to a term that you would have no contact while on probation with any child under the age of 5. Do you understand that?
Yes, Your Honor.
Also, that apparently the Department of Health and Human Services for the state of Michigan are working on some kind of plan, and that you agree to that plan will be adopted as a term or condition of probation. Do you understand?
Yes, Your Honor.
Okay. Have I gotten the agreement all right?
Yes, Your Honor. It's no unsupervised contact with any children under the age of
Yeah.
5. It's just said no contact, I believe.
All right, no unsupervised contact.
And
Thank you.
if there is a DHHS plan, that would be
Yeah.
part of the terms.
Have we got it right, Mr. Champion?
We do, it's supervised. No
Supervised, no unsupervised. I'm sorry, I stated it incorrectly.
Right.
All right, thank you. All right, by enter. Mr. Ringstrom, you can go ahead and provide me those exhibits. By defendant's counsel, speaking with defendant. I have those exhibits. Are you asking the court to accept People's Exhibits 1, 2, and 3?
Yes, Your Honor. Sorry.
Thank you. All right, Mr. Clark, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
By pleading no contest, if that plea is accepted, you will be waiving the right to have trial by jury, trial without a jury if you chose, and the court and prosecutor consented, the right to have be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question or cross-examine those witnesses presented against you.
All right, we're going to
the right
switch
have the
over
court
to
order
our
any witnesses you may have for defense to appear at trial, the right to remain silent during the trial,
feed from Darrell
the right to not have
Brooks.
its house used against you, and the right to testify at the trial if you chose to testify. Sir, do you understand?
We're going to mute that for just a minute because we're going to be taking this one here and switch to 3. No audio yet. There's Mr. Brooks in street clothes and a wheelchair with counsel present.
Brooks Jr., 21 CF 4596, 21 CF 5020. Appearances, please.
Matthew Torbenson and Shelley Grosso appear for the state. Good morning, Your Honor.
Attorney Russell Jones on behalf of Mr. Brooks. Mr. Brooks is present in court, Your Honor, in jury clothing. Good morning.
Good morning.
Jury
everybody.
clothing.
Hi, Mr. Brooks.
Hello, Your Honor.
We are here. It is the day that our trial was scheduled, but I have plea paperwork and I understand that the parties have reached an agreement. Mr. Torbenson, do you want to put the state's offer on the record?
Case ending 4596. The state anticipates Mr. Brooks entering a no contest plea to count 3, second-degree recklessly endangering safety as an act of domestic abuse. Based upon that plea to count 3, the remaining charges would be dismissed and read in for consideration at sentencing. As to case ending 5020, the state anticipates Mr. Brooks entering a plea of no contest to count 1, felony intimidation of a victim. Based upon that plea, the state would move the court to dismiss and read in the remaining 2 charges for consideration of sentencing. At the time of sentencing, the state will recommend that the court sentence Mr. Brooks to a substantial term in the Wisconsin state prison system. We would leave the ultimate interpretation of that to the sound discretion of the court. The defense would be completely free to argue for the appropriate sentence.
It also contemplates the amended information's not being filed.
Okay. Mr. Torbenson, you talked about count 3 as charged, correct?
Yes.
Okay. All right. Mr. Jones, is that your understanding of the state's offer?
Yes, Your Honor, and I actually did an attachment of an email string between the state and I for clarity of the record.
Okay, I appreciate that. And
And I had Mr. Brooks' initial next to the offer section.
great. You're planning or anticipating that it will be a no contest plea. Do you want to make a record as to why that is rather than a guilty plea?
Yes, Your Honor. My client is entering a no contest plea. In those discussions, I indicated that he understands that he'll be found guilty, but he is standing silent as to, he's not contesting the allegations because of potential civil liability, which he may or may not be exposed to with respect to these charges, and therefore we've negotiated a no contest plea. But I will tell you that he understands he'll be found guilty. This is not a maintaining of innocence thing. This has an issue. This is a legal decision based upon potential civil liability.
All right. And the state that was part of your offer, and you are willing to accept a no contest plea for those purposes?
I am understanding that the victim, Ms. Patterson, can still seek restitution in these matters if she so wishes. We are not objecting.
All right. All right. And the court is willing to accept it for the reasons that have been stated on the record.
There you go.
The named victim will have the opportunity to put in a request for restitution that is separate from a civil liability thing. It's so that will still be a potential that will be part of this. So, Mr. Brooks, it is my understanding that you are planning to enter a guilty plea today to
no contest.
See, I told you I would do it.
I know you did.
It is habit. I apologize. A no contest plea to 2 of these charges that are pending against you. Is that correct?
Yes, Your Honor.
All right. Have you had any drugs or alcohol in the past 24 hours?
No, Your Honor.
Are you on any medications?
No, Your Honor.
Are there any medications you're supposed to be taking that you have not taken?
No, Your Honor.
All right. You've been charged with a number of counts in each of these cases. It's my understanding that you're going to enter a guilty plea to the 2.
No.
Or, sorry, did it again. No contest plea to the 2. And then the other charges will be dismissed and read in. What that means is for the dismissed and read in counts, you will not face any penalty for those, nor will you have a conviction for them. However, when we get to sentencing, the state will make their argument as to the facts of the case, and they can argue the facts that relate to those dismissed and read in charges, and I can take those into consideration when I sentence you on the 2 that you entered the no contest plea to and that you were ultimately found guilty of. Do you understand that?
Yes, Your Honor.
All right. So for the 2
gets
that
it
you
wrong.
are
If he says
going to
guilty
enter the
or
no
not.
contest
No
plea
contest.
on, the first is a second-degree recklessly endangering safety with a domestic abuse assessment. That means that it is a Class G felony, and for that you face the potential penalty of a fine of up to $25,000 an imprisonment of not more than 10 years or both. That 10 years is broken down into two parts, 5 years initial confinement and 5 years extended supervision as a maximum. Do you understand that's what you're facing?
Yes, Your Honor.
In addition to that, because of the nature of the crime, that this is someone that you have been involved in a domestic relationship with, or either resided with, or have a child with, you would face the domestic abuse assessment for that, which is just an additional $100 penalty that would apply against you, as well as a federal ban on ever possessing a firearm. Do you understand that?
Yes, Your Honor.
All right. And then on the count 1 felony intimidation of a victim, that you're going to enter the no contest plea on in case 21 CF 5020.
That's the new charge.
That is also a Class G felony, potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years, or both, broken into that 5 years initial confinement and 5 years extended supervision piece. Do you understand that?
Yes, Your Honor.
I like
You
how they
also
put the
understand
Admiralty
that if
flag
you were
right
to be
next to
sentenced
him.
to prison, you would have to serve in prison each day imposed as initial confinement, because initial confinement time is not reduced by good time or by parole.
Yes, Your Honor.
You further understand that when we get to sentencing, I was not part of any negotiations, so I'm not bound by anybody's offer or recommendation. I will listen to what the state has to say, anything that the alleged victim has to say, either in writing or in person or in, I guess, any other form. Anything that your attorney says, anything that you say, and anyone who speaks on your behalf. I will take all of those things into consideration, and then I'll sentence you as I see fit, which could be up to and including the maximum penalty. Do you understand that?
Yes, Your Honor.
Do you also understand that because these charges are felonies, once you are convicted, there's some additional consequences, including the fact that you will never be allowed to possess a firearm at any time in the future. You may not vote in any election until your civil rights are restored. You will have to provide a DNA specimen to the Wisconsin State Crime Lab for DNA testing. And because these are violent felonies as defined under Wisconsin law, you may never possess body armor at any time in the future. Do you understand that?
Yes, Your Honor.
Do you also understand that if you are not a citizen of the United States of America, the plea of guilty or no contest for this offense with which you were charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law? Do you understand that?
Yes, Your Honor.
Do you further understand that if you enter a no contest plea, you will be giving up all the same rights as if you had pled guilty, and at the end of this, even if you enter a no contest plea, I will find you guilty of these crimes? Do you understand that?
Yes, Your Honor.
All right. So what is your plea then in 21 CF
One thing to
4596
say.
of second degree recklessly endangering safety with the domestic abuse assessment?
No contest, Your Honor.
All right.
Did it right.
And in 21 CF 5020, intimidation, felony intimidation of a victim.
No contest, Your Honor.
All right. Now I have in front of me your plea questionnaire and waiver of rights form. Did you go over that with Mr. Jones and sign off on it today?
Yes, I did, Your Honor.
Do you understand that when you say no contest, rather than asking for a trial, you give up a number of constitutional rights that are guaranteed to you? Those include your right to remain silent and not incriminate yourself, the right to see and cross-examine the state's witnesses, as well as call witnesses on your own behalf and have them come to court to testify for you, the right to actually have a trial, which could be a jury trial where 12 people sit together, listen to the evidence, and then must agree as to each element prior to reaching a decision, or a court trial where the judge listens to the evidence and makes a decision. And finally, the right to make the state prove you guilty by evidence beyond a reasonable doubt that you committed the crimes charged. Do you understand you give up all those rights when you say no contest rather than asking for a trial?
Yes, Your Honor.
Do you also realize you're giving up the right to raise any motions, such as suppression of the evidence, identification of you as the person who committed the crime, suppression of any statement you may have made, or
His
any
attorney's on
challenges to
Tinder
the
right now.
information or the complaint?
Oh, wait, that's text message.
Yes, Your Honor.
My bad.
Do you also realize you're giving up the right to raise certain defenses you might have, such as insanity, self-defense, intoxication, alibi, coercion, and necessity?
Yes, Your Honor.
Did anyone make any threats or promises to get you to enter into these pleas today?
No, Your Honor.
Did you read and understand the criminal complaints that were filed in these cases?
Yes, Your Honor.
And did you discuss with your attorney the elements of these offenses?
Yes, I did, Your Honor.
Do you understand that if we had a trial, the state would have to prove as to the second degree recklessly endangering safety that on November 2nd, 2021, at 7311 West Capitol Drive, that you endangered the safety of another human being, that you endangered the safety of another by criminally reckless conduct. That criminally reckless conduct means that the conduct created the risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and you were aware that your conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means serious bodily injury, injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury is great bodily harm. Do you understand that's what they would have to prove at trial if we had a trial in this matter?
Yes, Your Honor.
And you understand that by pleading
What's
no
the painting
contest,
on the wall?
you are admitting that you believe that the
portrait.
state has adequate evidence upon which they could convict you, and you are opting not to challenge that evidence. Is that correct?
Yes, Your Honor.
All right. As to count 1 in 21 CF 5020, do you understand that's the felony intimidation of a victim, that if we had a trial on that matter, the state would have to prove that between November 5th, 2021 and November 15th of 2021, from 949 North 9th Street, that, what are the initials? EP?
Yes.
EAP, was the victim of a crime, that you prevented, dissuaded, attempted to prevent, or attempted to dissuade EAP from reporting the crime to any law enforcement agency, and that you acted knowingly and maliciously. Do you understand that's what they'd have to prove as to the felony intimidation of a victim?
Yes, Your Honor.
And you understand that by entering that no contest plea, you are admitting that the state has adequate evidence that they could use to convict you of that, and you are opting not to challenge it. Is that correct?
Yes, Your Honor.
Have you had enough time to go over this case with your attorney?
Yes, I have, Your Honor.
Are you satisfied with his representation?
Absolutely, Your Honor.
Do you have any questions, or are you confused about anything we're doing
How
here
many
today?
stars would you
No,
give
Your
him
Honor.
on a
Are you
Yelp
pleading
review?
no contest because, again, you understand the state
Bug
has
Duggar,
adequate evidence upon
congratulations.
which they could use to convict you, and you are opting not to challenge that evidence?
Yes, Your Honor.
And are you entering this plea freely and voluntarily?
Yes, Your Honor.
Mr. Jones, have you gone over the plea questionnaire and waiver of rights forms with your client?
I did.
Are you satisfied that your client understands the nature of the charges, the elements, the maximum penalties, and all of the rights that he's giving up by pleading no contest, including the fact that he will be found guilty, and also including any possible motions or defenses?
Yes, Your Honor. And to that end, I also handed Mr. Brooks about 100 and some pages of reports today, just so he would have them. The witness list, the amended information, and there's additional documents I'll be sending to him. Although he has them on digital format, I wanted him to have them in paper format. We went through the no contest discussions. We also had a discussion, not just today in your bullpen, but also, and I'm not getting into the substance of it, but also on Saturday, we were able to have a fruitful conversation. So I think that Mr. Brooks is doing this knowingly and voluntarily.
All right. Are you satisfied that alcohol, medication, or drugs are not affecting your client's ability to understand what he's doing in court today?
I am.
Are you satisfied the plea is being made freely, voluntarily, and intelligently?
I am.
Are you aware of any reason in law why I should not accept this plea?
No.
Does the state consent to the jury waiver?
We do.
All right. The court approves the waiver and finds that the defendant is entering this plea freely, voluntarily, intelligently, and with full understanding of the nature of the charge, the maximum possible penalties, and all of the rights being given up by pleading no contest, and the court accepts that plea. Mr. Jones, may the court use the facts in the criminal complaints to stand as the factual basis?
Yes.
All right. Mr. Brooks,
Such firm
you said that
answers.
you read
Yes.
and understood the criminal complaints. Are you agreeing that you believe that the state could prove that those facts are true, and therefore you are opting not to challenge them with your no contest plea?
Yes, Your Honor.
The court finds that there's a factual basis for the acceptance of your plea, and based on your pleas of no contest, the court now finds you guilty of the offense
So
of
now it's
second-degree
done.
recklessly endangering safety with the domestic abuse assessment and felony intimidation of a victim in the manner and form as charged in the information, and I judge you convicted as of today's date, and I order judgment of conviction to be entered into the record. Is the state moving to dismiss and read in the 21 CF 4596 counts 1, 2, 4, and 5?
Yes, and counts 2 and 3 on 5020.
Okay, you got there before I did. That's fine. All right, those will be dismissed and read in for the purposes of sentencing. It is my understanding that we're setting sentencing off for another date. We will select that date in just a moment. At the time of sentencing, Mr. Brooks, and I am going to keep this. This was, I had this case in the domestic violence court. I came to another assignment, but I kept it because I had done much work on it, and I thought for continuity it was best. I will be transferring to another assignment in August. If we get a date before that date, I am specifically keeping this case. I will see it through. So at the time of sentencing, I am willing to listen to oral statements of counsel as well as anything that you have to say, Mr. Brooks, as well as EAP. If you would like to have a friend or a relative speak on your behalf, I'm more than happy to talk to that person. If there's more than one person who wants to do that, they should put their comments in writing and get them to Mr. Jones so he can electronically file them at least 3 days prior to that sentencing. If there are issues of restitution, that will be determined at sentencing if possible. Is there a request for a pre-sentence investigation?
No.
No.
All right. And
I'm not moving for remand. I normally would in a case like this, but given where Mr. Brooks is serving a sentence and my understanding that Mr. Brooks wants to return back to Boscobel, I'm not asking for remand.
Right, I agree with that.
Correct.
Generally, I would remand someone given the seriousness of the charges that you just entered into and that what the state's recommendation of substantial prison would be. But given your situation, I don't want you to have to be held in the Milwaukee County Jail rather than returning to the prison setting where you have been housed. So I am not going to remand for that specific reason. I know you will be held. That is the court's goal, that you be held in custody, just not necessarily here. So
Thank you, Your Honor.
You're welcome.
That's what he wanted.
All right, so I have some warnings for you. You may not have any firearms as you are now a convicted felon. The maximum possible penalty you face for violation of that is a $25,000 fine and a 10-year period of imprisonment. You cannot vote until your civil rights are restored. You may not possess body armor, and any no contact order remains in place
No
at
body
least until
armor.
after sentencing. All right, we will select a sentencing date, and I will see you then.
Thank you, Your Honor.
You're welcome.
Okay, so he was brought from
Parties
prison
available
to
August
Milwaukee.
9th at 9 o'clock.
No. That week, I can do any of Monday, Tuesday, or the
No.
Wednesday, not the Thursday or Friday.
That week is not good for this court.
Okay. Then the following week is a good week for me, except for Monday,
Okay.
No.
generally.
August 16th, 9 o'clock.
That'll work.
That
Works
works.
for the state.
Yes.
Next court date will be August 16th at 9 o'clock for sentencing.
Friday, August 16th.
So last minute, Darrell Brooks changed his mind. Instead of seating a jury this morning, he was dressed for jury selection. Then he decided to take a plea deal. Took a plea deal. So Mr. Brooks will not be facing trial. Soundbite, please. No soundbite, Lizzie Dog. No. Okay. There he goes. He's got his papers. I believe the wheelchair is basically. Oh, there we go. Let's cut from that one. It's done. It's a done deal. The wheelchair is just to make it easier for the bailiffs, because he has been a little bit of a problem at times. Mr. Brooks is like, I'm not sure if that day's not going to work for me either. I'm busy that day. We need that no as a command. No. I can do it. No. See that? What's a plea deal? A plea deal is basically where the state says, look, if you will agree and basically acknowledge your guilt, and it can be done a couple different ways. It could be the whole Alfred plea. It can be the no contest. It could be a guilty plea. But if you'll acknowledge guilt to these lesser charges, we'll dismiss the more serious charges, and we're okay with that. That's an outcome we'd be happy with. But then they sort of get to set they know what the outcome is going to be. And he took it. Wonder why? Because probably because the information came out that he had been calling and bugging the witness or the victim on the phone, and that would have gone very badly for him in court. So, no 3-hour claiming argument today. Nope. August 16th. August 16th will be sentencing. I'll be back from vacation by then. Why is it so far out? It's way out there. Did they say they were doing a PSI again? Because, I mean, I hate to break it to you, but whatever you sentence him to is not going to change his standing, his status. He's going back to the federal prison where he's serving time, and he's going to just hang out there. He does not like the jail. Does not like the jail. That might have been played into his decision. Well, that was a quick trial. So which one do you want to follow next? Hey, Nicole. Welcome. Good to have you here. Great to see you. Hope you're doing great. Love the orange Courthouse by your name, by the way. If I had a shirt that said Goodman Law Firm, I'd rep that one too, but I currently only have the Matthew Harris Law one. So let me know when you've got merch. Jail sucks compared to prison, I hear. Prison at least feels organized and has a schedule. Jail's like being in limbo. Yeah, and that's something that Mr. Brooks brought up when he was in court with Judge Darrell on the big trial, that he was frustrated because he was missing the requirements for coming over to court and going back. He was missing things. I think he was missing shower calls, and he was missing like the meal times and all sorts of stuff. It was people have been really inmates who get very accustomed to a schedule are frustrated by that. Did he have a new tattoo? Oh man. Wore my RA sweatshirt on day 2 so you can see me seated by the door to the courtroom all by myself. Nice. Follow Daybell, please. Selena, it's got 2 child victims in that one. And it's terrible. It's terrible. It's in break right now. Daybell's over on the Top Market Media channel. It's been PG. It's been PG, but it's not going to stay PG, I don't think. And so help me, if they start reading excerpts from his book in court, I'm out. I'm just kidding. It's crazy. It has been. I don't think it's going to stay that way. That's all I'm saying. Any more on Treehouse? We're still waiting. I don't know if a gag order's been entered yet. I know that the prosecution wants one, just like on the first time. If they do have a gag order, it might be really quiet until, of course, court starts. But no graphic photos shown. But those are coming. I mean, we know the facts of the case because we saw it with Lori. The court won't allow any photos published. That's good. If he covers Daybell here, Ashley won't be able to ban anyone anymore. Have people been banned on Top Mark? I've not seen anybody be naughty over there. Ashley's enjoying the ban button. Let's see. There's always so many child cases. Did you know U.S. is currently topping the charts for minors dying by homicide? It's pretty alarming, but also explains why so many child cases. There are quite a few. No, there's no reciprocity. Between the 2 channels. We don't even have, we have some overlap with mods, but we don't share all the same mods. Oh, saw on a channel called Justice is a Process. Bail was revoked for Ty, and he's in jail now. Wow. If it was revoked, it has been revoked for violating bail. So unless, like what? Violated the gag order? It's a fun group over there, Selena. It's awesome. You know. Okay, so Belinda, I'm not sure. I didn't see the image that you saw in his hair, in Darrell Brooks' hair. Gag order is on members. The judge can't really gag the media. Okay, there's the Constitution where you have some rights when it comes to media, but when it comes to people who are parties of the court, they can be gagged. So the defendant, the victims, the prosecutors, the defense, they can be gagged and they can be ordered not to share anything extrajudicially. Bug Dugger, did you miss anything good while I was at jury duty this morning? It was sort of quiet. It was sort of very, very quiet, as a matter of fact. Let's see if we can get this one shrunk down. See what else we have out here. I think we have Judge Simpson. Come on. Too many buttons. Judge Simpson. Put come on, too many buttons in the search bar. I was pushing the wrong button. Let's see. There we go. Judge Simpson, I think, is up. Let's see if we can jump over to him.
Hey, how long is it going to take you to get an attorney? Realistically, because okay, so you're going to be able to retain an attorney within 2 weeks, you believe?
I believe so. Yes. But to get him here. Yeah.
Do we need to back up? Well, she not? We're gonna back up. I want to see why she doesn't have an attorney. Let's see.
I get two.
Let's see. She's still there. Okay, let's try here.
Was rent due on the 1st?
That's still her. It's a long one. Okay, maybe it's this whole block has been her. So let's catch up on the whole thing, shall we? There we go. Bug Dugger, great news. Been off work for a couple weeks, but every day is better than the last. That is wonderful. On the mend.
United District Court for County of Washington, State of Michigan is now in session. All those having business before the court draw near, the Honorable Judge David Simpson preside.
You may be seated.
Love that bailiff, but I need to give him some pointers.
Yeah, you have. Good afternoon, Emily. Court does call the case of Jeff Lewis, Julie Lewis versus Jennifer, is it Loudon?
The Lewises versus Loudner. Swear him in.
Yeah. Loses that time. State your names.
Jeff Lewis, LUIS.
All right.
Jennifer Loudon.
All right. And You said your name is?
Jennifer.
Okay, you're Jennifer. You are,
Isabel.
and are you a party to this case or? Well, okay, I figured that part out. I mean, no, I really look stupid, but I'm not. I got that. Okay, so you're her daughter and you have something to do with the kid. Okay, all right. Just wanted to make sure. All right, so first things first, and I apologize about the delay in coming out, but I have an appearance filed from Darrell Martin on your case.
That was an attorney, but she could not appear in small claims. So if this goes to district court, she will be.
Okay. I'll explain momentarily what happens in that regard. Ms. Loudon, I should explain to you also that I know Mr. Lewis from, I probably haven't seen him in maybe a decade plus or so, but known him from the city of Ypsilanti, in row with the fire department, correct?
It's city manager, she down there.
Yes. So I do know him. It won't impact my ability to hear the case. I think. I don't know what that meant. But no, that's okay. That's okay. And I'm sure Mr. Lewis knows. I'm just going to call it like I see it. Everybody leaves mad. I've done my job. It's only half leave, and it's a good day. All right. So that's the first thing. Second thing is that there was so this starts out as a small claims action, correct? Yes. So it starts out as a small claims action. The moment, and an attorney cannot appear in a small claims case for either side. But the moment an attorney files their appearance, they're technically supposed to file what's called a petition in order for removal.
May I?
Sure.
I filled out, I requested for this to be moved out of small claims in the first place, and I filed the paperwork the day prior to it. When the magistrate called it, he said he didn't have the paperwork. I said I had a copy of it. He didn't even want to see it. All the things about my evidence. I wanted an attorney, and because there is definitely a countersuit going to be involved. And now I'm just trying to figure, the whole thing should have been moved out and done right, so I could have an attorney in the first place.
Okay.
And that's kind of what I'd like to do.
Well, then it all may work out because, so finish what I was saying. When Miss Barton filed her appearance, I got notification that she filed her appearance. That removes it to the general civil division. All right. Because the interesting thing in our court, when that happens, it doesn't change anything. You still have me. It's just I hear the case in a different fashion than I would if it were a small claims case. All right. And then certain appellate rights are also attached to general civil. So when did you say did you file a petition for removal?
Yes, and it was a name for the, I could grab my phone, I could give you the exact date and tell you what the form was called. I filed it with the first magistrate that, well, the magistrate that made the decision and prior to coming.
Sure. You see on JS printout a petition for removal.
On September 28th, there was just a free COVID bill that the defendant requested time to get an attorney to general civil on September 28th.
September. It's just free coded?
Yeah.
And ma'am, you said you filed paperwork?
I did. I actually have a copy of it on my cell phone. If I can get it, I can tell you the exact name of it.
Is your cell phone here?
It is.
Okay, go ahead. We peeled it. You said September 29th, right?
Judge is doing judgy things. Let him finish reading. Trying to figure out why. I know he explained it, but I was distracted. Why this start as small claims and it's going now to be not small claims anymore?
Try to get this. Well, you're looking for that. So Lewis says you filed on January of this year amended judgment amount.
Your Honor, what I had done was, my understanding was when she was moving this to district court, I asked, it was in small claims, the maximum $6,500.
Correct.
At the time, as Master only here, he only granted a $6,500 degree. When I was going to district court, I asked the court to consider actually what I wanted on the small claims, which is over $8,000. That was never addressed. Let me finish one thing. She did want to turn it back in September, so the magistrate adjourned the case 30 days so she could get an attorney. So when she came back on November 9th, she had never gotten an attorney. And that's why we had the small claims hearing that day. Because it had been adjourned a couple of times. That day, he goes, we're going to have the hearing today.
Judge
She was
said,
given about 40 days to get it.
like I start my day with this.
Got it. That was in September. In November.
They got adjourned in November 9th.
Got it. And then in January, you filed these documents looking to amend the judgment amount because you thought it was going to. Okay.
And what happened was then when the magistrate ruled, she appealed the ruling, then it was going to Judge Warren.
Correct. Okay. Did you find? Pardon?
She has not found it yet.
Oh, okay.
Demand an order for removal from all claims, and I had to have that out and sent to the judge before the case. So whether it was 40 days.
When was that?
This was on November 8th.
You missed the whole trial,
2023.
Salty.
It was, I believe, the day before the hearing.
Okay.
Took a
And
plea.
they say they didn't get it.
Yes, and I reminded him I had a copy and he didn't want to see it at that point. He didn't have my evidence or anything, I just heard the case anyway.
Okay. All right.
But I wanted it out.
Well, interestingly enough, you wanted it out of small claims. Not sure why, but that's okay. And then your requested judgment amount was in excess of what was offered in small claims. And so it's like everybody wanted it up in the general civil division, except the court didn't do it. So here's what we're going to do. We'll just begin the case as though it's in the general civil division. That will give you the opportunity, if the judgment amount is supposed to be whatever, get your proper amount. It will allow you an opportunity to have an attorney. You said something about a countersuit. I don't know. Has that been filed already?
I'm not sure how to handle this, and that's why I needed an attorney, but they didn't allow attorney in a small claims. So the way that I wanted to handle it was go to the general civil and have an attorney, because I feel like I have a pretty strong countersuit.
Suit and countersuit. know what happens when you countersue somebody?
Uh,
More lawyers get rich. That's it.
Hey, let me ask this so that we could try to get this case in an order that it can be heard. This was a rental situation. Underlying this was a rental situation, correct? And your claim is for back rent for a water sewer bill, correct?
Right, three things, it's owner rent, utility bill, $3,000, and then just minor damages that were done during the tenancy. Those are the three things we can talk about.
And briefly, in substance, your counterclaim would be regarding what?
Regarding multiple things, including an injury to an animal due to the neglect on the property. It's one of them. There is quite a bit involved in this case, and
That's what everybody tells me.
there really is,
And then-
and that's why I feel like an attorney.
How long were you there?
11.
Okay. You were in the property for 11
Yes,
years. All right. And was there a lease?
There was an old lease. They had given me a lease after many years. I refused to sign that month-to-month lease. I have a copy of it. I never signed it because I refused to sign it. And so there was an old lease. I did a couple extensions over the years. Since
Stop. So when was the last written lease?
it was an extension on the one I signed in 2013.
Whoa, $3.1
And then
million
you didn't
bail
sign
for
a new lease.
Tyrone.
No, we just winged it. Sometimes there was never one for years, and then she came up with a month-to-month that had a bunch of different stuff in there that wasn't things that we had agreed upon, and I refused to sign it because of that.
Okay.
That is huge. What are they saying? Why did they take him into custody? Why did they revoke the bond? Tyrone Tucker is the Treehouse
Just so
murder
we can
trial.
try to get some
defendant.
of this sort of straight. Did you leave in May of 2023?
I held over a little bit in April, waiting for the city inspectors to get in there. We had no hot water for 10.5 days.
Didn't ask that. When did you leave the premises?
The 7th May, I believe.
Of 23.
Yeah.
How much was monthly rent?
Well, technically, I paid $1,400 a month plus 50 extra for my ambulance. So it was $1,450. However, it was raised for a remodel that never got completed for 2 years and 60. So there's a lot involved. There was 2 years and 4 months of a remodel that was never finished, and my rent was raised a couple $100 for this remodel, and that was never finished. And I mean, I had no cover. Everything was free. So I believe that I should be owed back the difference for that one. I'm alone. But there's, like I said, there's a lot.
All right, I'll go back to my question. How much was monthly rent?
At the end of the lease, it was $1,500.
Okay. And you're disputing that?
It was $1,400. It was $1,400 plus 50 grand.
Okay. All right. So we're about $50 difference in that. All right. Who was to pay? Let me ask it this way. Was there an agreement that you paid water?
So there's
Okay, so I asked my questions yes or no.
Yeah, I paid the water bill, and I paid it a certain way the entire time I lived there. It was out of my taxes, and that was part of that. New
Paid it out of what?
I paid it out of my tax return, because the water bill is humongous in that. But there's definite reasons for it being that high that are my responsibility. Yeah, so there's a discrepancy on the water bill as well.
Okay. So you were paying the water.
Yes.
Okay. Because I see that there's about 3,000 water damage or water bill of some kind. So would you agree that if you remained in the premises, that you would have paid the 3,000 water bill?
Not after the evidence I have going on in the home with the water. Well, that's years of leaking. I believe that played a huge part in the humongous water bill in the house. I was not paying it anyhow because I was waiting for inspectors to get in there as I was trying to move out, just so I could fight that myself with paying that amount for the water bill.
Okay, but in the past, you paid the water bill.
I did for all those years, yeah.
Okay.
And it was always high, and I just thought the city of Saline has high water, I know that, and this and that, but I then was able to come across all of these reasons that the water bill played a part, I'm sure, in that high water bill. That shouldn't be my responsibility. So that was kind of part of my counter to.
Okay. But
$8,000 countersuit for water
the
bill?
agreement between the parties was that you were the one that was responsible for the water bill.
Yes, yeah, it was stayed in her name, but I paid it. Yes.
All right. So in terms of plaintiff's claim, I have $1,500 for, and this is just your principal claim, $1,500, $3,042 water sewer bill. Is that right? So on the principal claim, I basically have 4542 on that. Then you said there were damages to the premises, right?
That's correct.
Okay, stop there, because that's all I need to know right at this moment. Because, all right, was there a security deposit?
Yes, there was.
Okay, and how much was the security deposit?
It was 11. Check my sheet here. It was 11.
You agree with that?
So $1,100 was security, and there was a $300 non-refundable fee I pay as well, along with the first.
Okay, but the security deposit was $1,100. You agree with that? So then I see that plaintiff is claiming your claim was for 8702, right? Initially, although you realize the limitation was small claims.
Yes.
But the original claim was for 8702.
Yes.
It must be terrible to have to completely figure out a case and figure out where
So
everybody's
when I
coming
take
from.
the, well, let me also say this. You were there in May. Your claim was, I think, for $1,000 of rent for a half month for May.
That's correct. Attorney. She occupied till May 8th.
Okay. Was rent due on the 1st?
The rent was due.
Okay, so understanding that your claim, what both parties should realize is whether when you hold over, you call it a holdover, but actually you're just going into the next month, the landlord's entitled to that month's rent. Okay, typically, unless there's something different. So the distinction between the rent and the water, those are repairs. Let me just take your claim as you had it, which I think on the small claims form, you had basically $2,500 in rent because it says half a month. You just said $1,000.
3,000 for each utilities. And then on the termination of tenancy, I have detailed, and this is the court received this, she received this by law, they have to. They have everything listed, which calculated to be $8,902. I gave her a credit.
They're shaking her head. The daughter's like, stop it.
87. And on that second page, you'll see where I have damage deposit.
Well, hold on. You're referring to a document. This was supplied to the court.
I don't know.
Well, hold on. Let's make sure that. So did you give this to the magistrate at the time?
Yeah, it was mailed to the civil division. It seems that was mailed to Miss Love got 2 copies.
Okay. Hold on a second. All right.
While he's doing that, I am looking at the Multnomah County Sheriff's booking. I do see Franklin Tyrone Tucker is in custody up there.
When did
Portland,
you send
Oregon.
that?
It was prior to the hearing trial.
It was booked on the 3rd. They do show fugitive felony with the bail of $3.1 million. So he's still up in Portland right now, has not been transferred to Florida. Makes it really hard to prep for trial when you're in jail as a pro se.
You would acknowledge that you received it?
No, actually, for mediation, I received multiple phone calls from the court for mediation.
Ma'am. There's a document that I'm referring to right now. Plaintiff has indicated that the court received it and that you received it. Did you receive it?
I received a document.
Okay, I'm not going to get it straight. Let me see that document there.
I believe that is where his wife lives. He was arrested in the airport, getting ready to fly back down to Florida.
So here's what.
He's like, now I've read the details.
And I get 2 copies of that. So what I have is I have part of that. Don't ask me why. I've got the back pages, the ones, the pink one and the yellow. I don't have the front 2 pages. I don't know why. No, don't ask. I just have to deal with what I have. So
Foundation.
yeah. But those 4 pages, those were the 4 pages that were submitted to the court. Okay. I apologize. I don't have them all, but I now do.
I don't have
Now,
them. But now I
ma'am,
do.
did you receive? Did you receive 4 pages indicating itemizing the damages?
I have, yeah, I have a bunch of itemized stuff that was, most of it was not true, but,
Okay, I'm not asking if it's true. What I'm asking is, did you receive it? I'm just trying to, look, here's what I'm just trying to do. This is.
That's the original.
That goes back to the Lewis's. Then this, give her that copy. Yes.
Man.
Okay, so, and ma'am, just so that you understand, I'm not making any finding about anything. I'm not saying, I'm not asking whether the validity of the claim the Lewis's can substantiate. Okay? So when I'm asking if you received it, whether or not it's true or not, at some point we'll have to deal with that. I'm just trying to make sure we're all dealing with the same information from the get-go. You got that? Okay. So that document that I just gave you, which is a copy of the document that the Lewis's just gave to me, is that a copy of what you previously received?
it is.
Okay. So now at least I'm in the ballpark of what plaintiff's claims are. Now, the substance of your, well, before I get there, is it true that you did not leave a forwarding address?
I didn't.
Okay, all right, that's fine. That's all I need to know. All right, next thing. Without a whole lot of specifics, what's your counterclaim about?
If you don't mind, Isabella and I have both.
Go ahead.
So there's multiple things, for example, no hot water being, no renovations unfinished, permits never being pulled, multiple. There's a list.
So we have, yeah. We have quite a large amount of unlivable situations that we've lived with for years, proof of all of it.
Okay.
So there's.
All right. So then my question becomes, was there any point in time where then you vacated the premises because of those conditions?
I have been trying.
No, that's not what I'm asking. If you're basically what you're indicating to me, I'm going to put it into other language, is that the unit was not habitable.
Yes.
Okay, so then my question becomes, did you leave the premises?
I didn't, but my children had to for 10 days in April.
April of?
This year. We had no hot water.
Of 23. Not April of 24, because you weren't in the premise. Okay. All right, so they vacated for 10 days.
Yes.
All right. when these conditions existed, did you notify, this is in the city? Pardon?
It is in the city.
Did you notify the city?
I did.
Okay, did they come out and do an inspection?
That's where it started.
Where what started?
I called the city to do an inspection. The person that I talked to gave me an email to send them some information to come in the home. The following morning, Mr. Lewis was in my driveway taking pictures and I called the city. They never came to inspect. I called back a couple of occasions over a few days. It started a third day we were out of hot water in Pickles. It's the first call that I made to them.
Ma'am, this is gonna get real long if you don't just answer my question.
I called them.
Okay, that's all I needed to know preliminarily. So there was no city inspection.
She's slowly losing her case as well. She has all the reasons, but the law has, requirements and stuff.
So that we can put this in. So I guess to the Lewis's, Miss Martin's going to be representing you. Is that it? Or
I would prefer to continue that with.
I
Ms.
know.
Martin told us that the court said she couldn't be here. It's fine. I didn't know that she, we only want her here if she's allowed.
Well, she will be allowed because I'm going to handle this as a general civil matter. It just seems to me that that's what you guys wanted in terms of the amount of your claim. And it sounds to me also like that's exactly what defendants wanted in the matter. So so that everybody's aware, I'm kind of, without fully starting over, I'm trying to just start over and then try to move the case along. It may not move along as quickly as you want, but that's where we are. All right, so if I'm hearing you correctly, if an attorney's allowed, Ms. Barton will be representing you. Is that okay? Because so that you know, because she filed an appearance, most of the notices will be going to her. So I wanted to make sure we had that because she sent in her appearance. Okay. You are going to get an attorney. Okay. So when is that going to happen? Okay, I don't know what that means.
She said soon.
Is this being scheduled for today or another day?
Pardon?
I'm just confused. Is this being scheduled for today or another day?
Scheduled.
Oh.
Okay.
Yes.
So how long do you? Yeah, so within a couple of weeks. I'm sure within a couple of weeks. We have a couple that we've been speaking to already, just for advice purposes.
We have lots of attorneys.
We're trying to get one first week.
Okay, so folks, listen. This can get real bad. I've got an appearance from an attorney on this side. I think Miss Barton will show up. That was part of my delay because I thought she was going to be here, so I was waiting to come out until she got here, but she wasn't going to be here. Now I get it. So how long is it going to take you to get an attorney? Because listen, they've got their claim, right? They've got their attorney. And what I'm going to ultimately instruct Ms. Barton that she's going to need to do is she's going to have to put what their claim is in a proper legal format. She'll understand.
Thumbs up.
So how long is it gonna take you guys to get an attorney?
We could probably get an attorney pretty fast. I'm sure they're gonna have to put things together.
It might take about a month to get all of our evidence together for an attorney.
Okay, so look,
Judge's soul left his body. He collapses. Face planted into the paper.
I'm always looking at a time frame. I'm a judge that has to run a docket, and that's what I do. Well, they do that, but I just show up.
Can we have a?
Folks, listen.
It's not that hard.
Okay, so here's what I'm gonna do, okay? Because I got an attorney on this side. I'm gonna set I need to know when can you have an attorney? Then I can work with the attorneys regarding making sure that paperwork and everything is in line. But I can't, well, I can, but this will take forever if I have to continue to go through this way. All right?
It's going to take a long time.
So I think
And I don't have forever. She's got forever. I don't have forever. So when can you have an attorney? If I set a date, can you have an attorney here?
have an attorney here.
Like here? Like in court here? Here?
How about, within, have the attorney and have them here like what, a month, within the month? At least a couple of weeks by a month at the longest. I see what we have.
This is the mother-daughter team on that table.
How long is it going to take you to get an attorney? Realistically, because okay, so you're going to be able to retain an attorney within 2 weeks, you believe?
I believe so. Yes. To get him here. Yeah.
Got about $8,000, $9,000 in claims, countersuit back and forth. I honestly think if somebody gave them a phone book, they could have an attorney by now. Just like, he's done. He's done. So what date are we going to give this stellar couple? Think of the poor attorney. The poor attorney who has to go through all this.
Day after the holiday.
Day after the holiday. We have a holiday coming up?
Okay.
Oh, Cinco de Mayo. Do you guys celebrate yesterday, by the way? I made a gallon of fresh garden salsa. And because I live in North Carolina, you can't get peppers here.
Okay, so here's what I'm going to do.
I couldn't do any heat.
I'm not going to direct that plaintiffs put anything in any form as of yet, okay? Because I have to see what's going on this side. And rather than run up that cost at this point, just do it that way. I was going to set a hearing for the 28th. Okay. So by that time, do you guys believe that you can retain an attorney?
That's 22 days. 3 weeks. If they show up without an attorney, he's going to be so mad.
So what I'm going to call this first thing, because I want to make sure that everything is in order. So I'm going to just call it a status conference rather than some formal part of the proceedings. It will allow you to have your attorney present on the plaintiff side, I'm not expecting anything from anybody at this point. I just need, if you're going to be represented, then I need to have an attorney here. If you're not going to be represented, then you're going to appear here by yourself, and then we're going to work through what you got to do to get this case moving to trial. Okay? All right. From the plaintiffs, any question regarding the court having that procedure? Yes, sir.
Just what time do we have to be here?
9 a.m.
Yes.
9 a.m. And it's likely that's not my. I won't be in my courtroom. I'll be in courtroom A. But they should be able to find me if I bother to show up. All right.
She's seriously
Do you
debating
have
not
any
doing it.
questions regarding that? Other than that, no. All right. On this side, any questions you have regarding that?
No, so I should hold off on sending any evidence to you, video or anything that would be the case. I should wait for you.
If you're going to get an attorney, I'd wait, because even, quite frankly, even if you send it to me, I've just asked very preliminary questions. So anything you send me is going to be out of context for me anyway. All right? Okay. Now, I will say this. Anything that you send, if you do try to send something to the court, it's got to go to the other side also. Okay? So you got to make sure. So you can't send things directly to me.
So if they have evidence, I haven't received anything, I should see everything that they put into any kind of court file as far as evidence goes. I should get a copy too as well.
Well, what evidence are you talking about?
If they've given any evidence for any of this, I should have copies of it.
Okay. Yes.
Okay.
But is there something you think that they've sent that you don't have?
Well, the magistrate in the last case said, oh, I have all your evidence here, everything's looking gold, you got your paperwork done, bam, and I'm like, well, I didn't see anything that they submitted, so they just sued me for all this stuff, and most of it isn't true.
Did he actually say bam? No, I'm kidding. So
I just make sure I understand that works for both parties.
yes, it does. But what I'm worried about is, are you saying that there was evidence that was submitted to the court that you don't have?
I have no idea.
There is something, we need the first, we do not have that, that's all.
All right, but was that submitted to the court?
It should have been if that was the only lease residing, like.
Well, no, because, okay, so that you understand, and maybe you'll understand it better when you get an attorney. If that lease expired,
Poor attorney has to
whatever
explain it.
lease you were on, if there was an extension and it expired, yes, the court can look at that lease, but by law, you're a month-to-month tenant. Okay, so at this point, I'm not sure as to the relevancy that it would necessarily have, but if you think it has some relevancy,
No, I'm just questioning, thank you.
all right.
Yep.
So and what you can do is you can go up to the counter once the file gets up there, and you can look through the file. If there's something in the file here that you don't have, they'll make you a copy of that, okay? And you can do it that way. Anything else? No? Anything else from this side? No? All right. We'll see you guys at the end of this month. Thank you.
Just like, I sure hope you have lawyers, because I don't want to deal with you directly at all. Period. End of story. I think that's a common occurrence where somebody gets taken to small claims court, or, well, where they have this initial appearance, and one party thinks that this is the time to bring all the witnesses.
So when did we decide that?
Pen drop. Uh-oh. Britta, thank you very much. Braxton, thank you very much as well. 2 generous gifts. And he's done. Just like that. We're shutting off the stream. All right. Oops. Whoa. Don't want that. That was loud. All right, where are we at? We're on a Monday. Darrell Brooks sort of hosed us for today. We were planning on following his proceedings, and he took a plea deal last minute, which means there won't be a court. Got a phone call. Hang on, let's see what's happening here.
Call from Braxton.
Braxton, how are you doing this morning?
Oh, I'm doing all right. How about you?
It's Monday. It's a good Monday.
It is Monday.
I have indoor plumbing. What could be wrong if you have indoor plumbing?
Hey, you have indoor plumbing. That's fantastic.
It's progress. Oh man, what's up?
So, what are your thoughts on Ty?
Okay, so we followed the Treehouse murder trial. Ty, I've said all along he should have a lawyer, but he hasn't been terrible. Right? He hasn't been terrible.
No.
I think he's done, I would say, better than most when it comes to pro se. I think he has good legal counsel that is sort of guiding his steps a little bit. But the problem is he is very, and rightfully so, he's very emotionally invested in this, and he gets distracted by things that I think don't matter as much in the eyes of the court, but due to him. And so I think that's a little bit of it's an obstacle for him, handling court proceedings and everything else, because it's personal. It's very personal. So this whole situation about the missed UA, I've heard a couple different things, and basically he's ordered drug tests, okay, and he's passed every single one for ages. He's been doing these, and he passes and he passes and he passes and he passes. No problems, no problems, no problems, no problems. And then he shows up. I heard he was late for one, and he shows up and they wouldn't test him. And then he showed up the next day and they wouldn't test him. And so they're like, oh, you missed a revoked bond. And he's out of the state. Oh, clearly he's a fugitive. Send the marshals out, go pick him up in Portland. And they got him at the airport as he's about to fly back to Florida. It does seem very suspicious that this response happened when it did, as quick as it did, after a missed UA, when there has been no problems before at all. And it's immediately right on the heels of the prosecutor asking for another gag order because they don't like what he's doing before court starts, which is talking about court. So it looks bad. It stinks. It really stinks. But this is what Ty says he's trying to expose, is this corruption in the system. I found that most people that say there's corruption in the system really just don't like the fact that they, might have done something wrong. Most times when people claim corruption, I don't think it's there. I'm not the tinfoil hat guy that says, every prosecutor is out to put innocent people in jail. I think there's some bad apples out there, and Ty might have found some, and I don't know, Karen Reed might have found some as well. So
it looks that way.
We're reserving judgment on those ones, but no, it's
exactly.
It's frustrating, especially when you've got a pro se defendant, and this seems like a small thing, like a missed UA, especially if they can verify that he showed up and they wouldn't test him, and it's like a clerical issue, or his driver's license had expired and needs to be renewed, and they're like, oh, no, we can't test you because the ID you're showing, it expired yesterday. That is like, that's not grounds for a $3.1 million bond.
No.
So, yeah. Anyway.
And I have to thank Matthew Harris. He answered the question.
Yes, and beautifully so.
As far as we know, the bond is not forfeited.
Yeah, and that's the $1 million they put up before. that allowed him to
Yes.
be out this whole time. And so, yeah. I'm wearing my Matthew Harris shirt today, and you
Nice.
giving him props. That's great. I learned tons
Oh,
from him
yeah.
as well. Everything I know, I learned from Matthew Harris. So, anyway,
Yeah.
crazy. So
I'm
yeah,
worried about him.
it's worrying. I'm mostly worried because it's very difficult to prep for a trial in jail.
Yeah.
I mean, it's not like he has a ton of witnesses to call, but even that, it's very difficult to just do the legwork to get ready for defense. And I realize it's round 2. I mean, he's been through it once already. It's not going to change a ton from what he had the first time through. There will be some changes, obviously, with Paula passing away.
Yeah.
But it's I think he's experienced. He knows what's happening. I think he can pretty much find his way through his orders. Although his big order that we read on the channel last week, his motion, it gets he's not a lawyer, and it shows in the motion. But I don't know. I think he's still. I realize his pride's on the line, and he thinks he can do it. I think he thinks he's the smartest man in the room, and he might be. But it's still, I think, is a good deal to get a lawyer, especially if you got one that's like counseling you on the outside. And
Yeah.
you know, money, I assume is not the reason why. It's not a funding issue. If you can make $100 million bail, and I'm not sure if it was cash bail or 100,000, but either way, 10% of $1 million is still a ton of money for most people to come up with. So, my advice is get a lawyer, get a lawyer, get a lawyer, get a lawyer.
I have a feeling that if he doesn't get out again on bail, if they can't put up the 3.1 million, then I think he might consider a lawyer, but I'm not, this isn't a knock against him, but his pride is so integral to this case for him.
Yeah. And that's who he is. I mean, we've talked with his wife here on the channel. She's called in and she's given us a little insight into Ty, and you know, this is Ty. This is Ty being Ty. And I think if it weren't for the fact that he's being tried for murder, I mean, all props to him. Go for it. On a smaller case, I'd say do it. But this is serious. This is really serious, and you don't get lots of second chances. In this case, he did get a second chance. I think you learn from this and you move forward. We probably have to file access for this one. I don't know the dates of Tyrone's case when the hearing is. Is it June 17th?
Yes, June 17th.
Okay, we'll probably have to file for access of that one again, and see if we can follow that along. But I don't know. It sounds like the state's not, or the court's not really excited about any visibility into what's going on, especially if they're trying to shut down what he's doing, which is interviews and the like. And it's not like he's on CNN or Fox News or MSNBC. He's not on these big channels spreading this story across the nation. It's very local. It's probably got a very limited audience. I don't think they've poisoned the jury pool by what he's done before or what he was doing now. But
no. Did you see that in the article I sent you, they had the actual jury vote? It wasn't the 11-1 that the prosecutor said it was.
What was it?
9-3.
9 guilty, 3 not guilty?
Yes.
Wow.
Yep, it was a 9-3.
I think it's always easier to hold on to your lone outlier if they've got support. So 3 people can band together and be like, nope, we're not budging. This is where we stand. But if you just have one person, like we had in not the Apple River, but the Arizona Rancher trial.
Kelly.
Yeah, it's rare that I think one person holds out.
Yeah. But the fact that it was a 9-3 and not an 11-1 makes me feel better about his chances. But
yeah, it's the problem. The problem is, I think his his pride and his knowledge of the law, which he has significant amounts of, I would say both,
Yeah.
are clouding some of the decisions he makes. And when he goes into court, he knows that the state doesn't have evidence. They can't pin it on him. They're like, and he's sticking with that. He's like, you can't prove it. Well, guess what? To the jury, that sometimes sounds like na 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 na. You know, you can't catch me. And I think even just changing some of his terminology or some of the way he phrases this to just a declaration of innocence. Instead of saying, I've outsmarted the state and you can't prove it. Even if I had done this, you can't prove it. That's not the way to win the hearts of jurors, win the hearts and minds of jurors. If you can get up there and stand and you say, I was not there, that was not me. You know, I've never been participating in anything like this. And, you know, deny. Of course, that needs to be true, okay? Because you know, some jurors can sniff out a lie pretty quickly. But I think that would do better. And in the last case, that's not anything I heard throughout the whole trial. It was all, they can't prove it. They can't prove it. They can't prove it. And, well, the jury looks at it and says, circumstantial evidence. Yeah, 9 of them said it's proven enough for me. So, anyway, I hope for his case, obviously we want justice. And if the state hasn't proved it, I am on the side of letting somebody who may have done the crime be free because the state hasn't proved it. They need to prove it. Okay, everybody is a big fan of the state being required to prove it when they're the ones who are falsely accused, right? That's when you become a stout believer in this principle that, you know, I am innocent until proven guilty. And unfortunately, a lot of people think, as we've seen in jury selection, the scary thought when the lawyers ask in the voir dire, they're like, well, you know, do you think, sitting here at my client, do you think he's done something wrong? And people are like, yeah, obviously. I mean, he's been arrested. He's here in court. He's here for something, you know? And I'm like, wait. Yeah. The judge just barely, last words off the judge's lips were presumption of innocence. He's wrapped in a cloak of innocence. And I don't know how else to teach people or to stress that to people, that innocence is real. And it's there, and you have to mentally be there and say, if the judge just said, wait, we're done with trial, jury, go deliberate. At that time, you have to find him innocent if it hasn't been proven otherwise. But yeah, so.
Yep.
Anyway, I went on a rant there. Sorry about that.
No, I love your rants. They're fantastic.
Oh, I don't know. Here's what I hope. This is what I hope for him. I think if he goes pro se again, which I believe he's doing, I hope that the new judge, which I don't know much about him, it seems that he's very similar to the last judge in some of the rulings. Obviously, I hope that the judge at least looks fairly at the motions that Tucker puts forward, because I think there's some evidence that should have been allowed in that wasn't. There's some, especially when it comes to looking at the detective work that was done, the investigation, how it was processed, the missing evidence, the chopped up videos. I mean, there's stuff out there that's like, hey, there's reasonable doubt just written between the lines here. We have to be able to look at that. You can't just say, nope, I'm not going to allow you to question anything. You just have to have, you know, I don't know, an alibi, or else you're guilty. So I hope that the judge looks at this and weighs his motions. Honestly, I like when a judge is a little bit generous to a pro se defendant. It's not fair, but they have the presumption of innocence, and they don't have the legal knowledge. They have the right to defend themselves, and, you know, tripping someone because they forgot to include something in a motion that was, you know, well, this is the process. You have to, you know, you put your relief section at the wrong part, so I'm going to dismiss that motion. No, I think the judge should be a little more fair. They should be a little flexible, and not necessarily teach them the law, because they shouldn't do that. But it seemed like Tucker the last time around was just similarly. I can't even say the word. It was shut down, just like make a motion, shut down, make a motion, shut down. And that was frustrating. Somebody spell it in chat so I can say the word. Similar. How many times? You say it.
Summarily?
Yes, that works. Like.
Yep.
Okay, there we go. Similar, not similar. It's just like the words in my head. Summarily. Thank you, Adam. Summarily. There it is. This one, Reverend Beasy. Whatever this word means, that's what I was thinking in my head when I said it.
Summarily dismissed.
Yeah. Anyway. So yeah, it's frustrating. We're going to keep an eye on that one. Obviously, it's weird to root for the underdog, but in his case, I really did not feel the state proved it the first time around. I think that the questions that he brought up, some of them, I mean, some of his stuff was out there, and clearly, in my opinion, should not have been allowed in. It wasn't, but I didn't like how he questioned Paula. I thought that really probably hurt his image in the eyes of the jury. Anyway,
I agree with that one.
I hope he does better this time. I think he's learned a little bit. I still think he needs a lawyer, but I'm hoping, because unless the state's evidence changed, he shouldn't be found guilty in my eyes. Thank you, everyone, for telling me all the different ways to say this. I can't read them. My mouth will not say that word today. I don't know why.
Yeah, I think that here's my worry. I think that based on the evidence of the case and the rulings in the previous court, if he had been found guilty on the previous one, I think that there would have been tons of opportunities for appeal, except they were not preserved properly.
Right, which a lawyer would know how to do. Yeah, and that requires a couple things. The first one is a timely objection. Mm-hmm. That is key. I mean, if it's like the best example for this that I can think of is like when you're playing Monopoly with your brothers and sisters. Okay, if you roll your dice and whatever, and you land on their property and they don't notice, and they've got hotels on there, and you just keep playing, and they just forget to charge you rent, and the next person rolls, it's too late. They could be like, wait, you owe me $2,000 because I have 2 hotels on Park Place. It doesn't matter. It's too late. The time for you to file that motion or to raise that objection was during my turn when I landed on your property. And because you didn't, and this is like just fair rules in Monopoly. I think if there's like competitive Monopoly playing, I think this is like an official rule. You have to do it in the turn. You can't go back and say, wait, last turn you landed there, you owe me. You can't go back in time. And the same with the law. You've got to file a motion during the time. There's a specific time when specific motions are sort of allowed or right to be filed. And certain things have to happen before you can file the motion. And there's a certain window where you file the motion. And if you miss it, you miss it. And then for all your appeals down the road, you missed it. And that one's not available to you. So that's something that's very difficult to do, pro se, because there's just one of you. And you've got one brain, and you have to not only listen to what's going on in court, what the judge is saying, and what the witness is saying, and prepping your questions and keeping your notes there, and also making the objections. It's a lot for a lawyer to handle, but the lawyer doesn't have that personal connection where you suddenly get offended because they're calling you something on the stand, and next thing you know, you've missed a piece of evidence that came out, and it's just hard. It's hard to do it yourself. Not recommended. 0 out of 10. Would not try again.
Like, I think that one of the best pro ses that we've seen recently is actually, and I say best as in as good as a pro se can be. I feel like it was the Airbnb trial. He did surprisingly good.
Okay, now we're giving him some credit, and I have to say, I think he only did that well because he followed in almost every moment in the trial. He followed lawyers who were defending a client for the exact same charges. So he literally 100%. Could just parrot anything they said. And it was identical. When it came to things specific to his own trial, that's where we saw the pro se stuff come out. We saw just weirdness.
Yep.
And then nothing else. And he didn't know what to do. He didn't know what he didn't know. So
yeah.
if it
And
wasn't the
biggest
same
problem.
situation for Mr. Robinson, then the accused just, didn't know what to do.
Yeah. Yeah. This trial is a mess, and it's really difficult because this is the first trial that on this channel that I really truly jumped in and got invested in.
Yeah. It was
so
it's a fascinating trial. It's unique. Obviously, anytime it's pro se, it's unique. But you have to admit it was the thumbnail, right? The thumbnail just drew you in.
Oh yeah. Oh yeah.
I do love the thumbnails. I'm always torn because in almost every case we're talking about, generally somebody lost their life. Was seriously harmed, and I'm always torn between making a cartoon about what happened and representing in a fun and informative way how the court system works and what parts and pieces were in it. And for me, I'm a very visual learner, and the thumbnails for me,
yeah.
I look at it and I can remember the court now. If without the thumbnail, it's like Airbnb what? It's just not there. So it's good.
Yeah.
Braxton.
It's going to be a real fun one to follow.
It will be. We're looking forward to that. What's on the schedule for you? How is the A+? Is it going to line up?
The A+ is great. I've got that. I have 4 jobs that I've applied to so far.
Sweet.
And I have an interview for one that's coming up.
Awesome.
So,
well, go ahead. You can put me down as a reference, but I can't. No, I'm just kidding. You might not want to. Make sure you win the internet and put that as your cover sheet. That's, you're in tech support.
I try, but I don't know how these people in chat like Kim manage to just be there.
Click on refresh. That's the giveaway. That's how
I've considered making a bot to do that exact thing, just so I can win it once.
You could sell it. You can rent it out for people.
Ooh, there we go.
That's awesome. Well, Braxton, good luck to you. Super excited for you that you got that certification.
Thanks.
And hoping that pays off big time for you, because I know you're one of the good ones.
Me too.
Appreciate it, Braxton. Thanks. Good talking to you. We'll see you.
Good talking to you too.
Bye.
See ya. Bye.
Can you put the burner phone number as a reference? Just know, Lenovo, when you do, it will probably come in as a spam call, and I'll treat it as such. I make no promises. Oh, let's see. I'm offering an internet winner certification. I'm gonna sell it. I've got a blank one to sell. For the low cost of 50 cents. All right. Let's see. Where are we at? What to do? I did not see Judge Boyd. Did anyone see if Judge Boyd, if her person came back? I think Judge Simpson's back. Just one second. Look who's here. If we hold really still, people will think we're a statue. Anastasia Helton, welcome. Good to see you there. Is she, she's not in custody. They wouldn't have like pictures on the wall and things like that. But the cinder block wall makes it look like an institution of some sort. Someone has found the little ducky and is squeaking it. The squeaky toy. Kim, we were just talking about how you're able to win the internet. That's it. Yep. Definitely not in custody. I think she has a phone with her. Maybe in school, culinary school, bathroom stall, all good choices. Is that a Cintas? It's like a Cintas, which is a company that does work uniforms.
14A District Court for County of Washington, State of Michigan, is now back in session. The Honorable Judge Day 765.
May be seated.
Judge, you're in one. There you are. Okay. Wow.
Court
Internet's
calls
slow
the
right now.
case of the People versus Annalise Corral. Corral.
Anastasia was like, "That's my name." Oh wait, no, it's not.
Under Natalie Pick for Miss Farrell, who is a plaintiff.
Need a new printer. All right, what do we do?
We have a Swahili
Respectfully
interpreter.
requesting a 2-week adjournment in this discovery with Miss Farrell. May 20th at 1 p.m.
The fancy
Matters
background is the
May
Swahili
20th.
interpreter.
2024, 1 p.m. Bond continued.
Anastasia is on the run. She's running. She's going.
What was that like? Never mind. I know.
She looks like she's in like
Courthouse
a
case,
nuclear
People
bunker.
versus Jason Hare.
Now, is that about the people? This is the public defender Natalie Pick, who is broken.
Your name, sir?
Jason Aaron.
All right. What do we do?
Thank you, Your Honor. As to the pretrial, we are requesting a 2-week adjournment in order for the prosecution to check with the victim as to potential offer in this case.
May 20th, 2024, 1 p.m. Okay, bond continued. Thank you.
Your Honor, if I may respond briefly.
Sure.
It is my understanding if he was meeting with Ms. Veloso, that I believe she does have the complaint witness here who would like to give a statement. She may have worked with her for information. And Your Honor, that is correct. The victim is here.
And what is their wishing a change in the bond conditions?
As to the no contact.
Oh, okay. All right. Where is she? Sir, I'll have to ask you to have a seat. Hello. I'm very well. Your name? Yes, ma'am.
It's okay, I'll go back to request for a consensual contact with Mr. Aaron.
For something other than,
Well, we have 3 children. Jason has been the primary caregiver in the morning time when I go to work in the morning. Having a hard time getting reliable childcare, so I can go to work to pick them up and take them to school. I have used up all my personal time to make sure that my children are able to go back and forth to school because of this no contact order. So I
well,
benefit the children to get back and forth to school and maintain my employment.
well, I don't know what that means, but I have consensual contact for childcare. Is that not your understanding? Oops.
No, Your Honor, my understanding is that third-party contact would be allowed for child care, but there was still a no contact order as well as the address.
I don't know where Mr. Our interpreter, Abdallah Mukoma,
Well,
is. But that's interesting background.
I didn't do the arraignment. I don't know what third party, yes, if you read that as one sentence, third party consensual contact for child care.
Third party consensual. Anastasia's taking us on a
You
tour of
already
the
have.
building.
Go ahead.
How that has been working out is Mr. Aaron's godparents as well as his mother have been often needing to go between picking up the children so they can have parenting time with that, and that is his understanding of the condition as it was set and what he has been doing at the time he's requesting it to be set as they have contact with the
So they're trying to change both the complainant and the defendant want the terms of this bond changed so
Well,
they
as
can
soon as, well, I'm trying to figure out what this
meet
means.
to
Do
exchange the kids.
People have a position on this?
Assistant Prosecutor
prosecuting attorney working for us on behalf of people. There are notes reflect that there is consensual contact allowed for the purpose of child care. However, the bond form indicates that there's third party contact. I think that so long as the record is clear that consensual contact is allowed for the purpose of child care, that would satisfy both parties.
Where did his understanding of that condition come from?
I believe we're in the bond form, Your Honor, that third party contact is allowed for child care.
Anastasia cannot sit still. Maybe she just needs a quiet place. Ooh, office chair now.
Where do you have it? Who did this arraignment? Hillary.
The judge screwed up this bond.
Third, okay, I see the bond form, and it indicates third-party consensual contact regarding 3 children. So ma'am, your understanding, so what's been happening with the children? Because I'm going to tell you how I interpret this and what this means, but go ahead.
So I've been having to take the children on my part to my family's house because I understood that there was no contact between Jason and I. So that was the contact for the very long week throughout the week to find reliable child care. So in order to not have the burden to find reliable child care, I was asking that Jason have contact to take the children for me.
To do what?
That he would take the children, we could take them to school.
Okay. So I hear you. I'm just trying to figure out how would you see that working? Because you're on hogs, right? So how would you see that child care exchange happening, I guess?
Well, you would have to come to the house.
Well, which is the other provision. Third-party consensual contact regarding children. I just don't. So what were the people suggesting? Because
Our request was not for a third party, it was to use like the My Family Wizard app or text conversation with regard to child care in the form of consensual contact. I think that if this were modified to allow for consensual contact, then with regard to child care purposes only, that would satisfy the victim as well as the defendant.
But then I would have to lift the no-go to. Because from what I understand, what she's indicating, that's where he would go to pick up the children. So you're asking me to get rid of 2 conditions. The people's request for the third-party contact was for communication really regarding children, correct? Is that?
Your Honor, our initial request was not for third-party contact. It was to have direct contact through written exchanges with regard to child care. I believe where the third party came in was in the child exchange. So as to avoid in-person contact through custody exchange.
Got it.
I was worried Anastasia was going to leave us there for a minute.
here's, and ma'am, so that you understand what I'm trying to think this through because of what you told me. I don't, in theory, have a problem with what you're requesting. It's just how to make that happen because I'm not going to lift the no go to provision. Right. So it's how would that be accomplished? Maybe I'll ask you this. Maybe I'll ask you the hard question. Hurts your brain too. Okay.
Share the pain, Judge. Share the pain.
Okay. So explain that to me. I'm just trying to think. You leave at 4:30. You then take, how old are the children?
6 and 2.
Okay.
I have to take them to my sister's house.
You take them to your sister's house, and then he shows up at your sister's house to take them to school, or what happens then? I guess
She would have to take them if she's able to watch them, and that's not been consistent. That's the issue. I don't have a reliable child care.
Got it.
It was quite dependent on the child. I don't have anybody else. I have a who's disabled. I have a father. Jason's my support.
This is tough. I don't know what the charges are in this case.
You would envision this being at 4:30 in the morning, the children go there, or tell me what you're envisioning, because then I can.
I'm envisioning getting up for work and being in my car and out the door when Jason gets to the house. So there's very bad contact. That's what I'm doing.
These charges would have to be dropped for her to get what she wants, I think. And if this is a domestic situation, that'd be
Is
sad.
your schedule in terms of your work consistent? I mean, is it the 4:30 every day, or is that how it operates for you?
Ooh, Abdullah.
Okay, so, and again, help me here because I remember those days for me, but I usually, so the 3 are there. You leave at 4:30. The children would go with him, correct? Okay. And then how's that flip around on the other side? Oh, you pick, okay. So then, because your day would have ended, you can go and get them from school. So it would really be on those days 3, well, it would be 1 time per day, really, that
the interpreter is
please.
the judge is like, we need to sort this out. The interpreter is showing us the rare knee view. Judge is looking like, that's our interpreter. All right. Okay, cool. I think he's in a tent. And he's tired. Swahili interpreter. Probable cause affidavit for Ty's arrest is sealed. Whoa. That means we won't hear about it until court. Dolphin lover, Kim, I have ice cream. I have cookie 2-step ice cream. in the fridge, unopened. But my kids have found it. And so I need to probably take a lunch or the ice cream will be gone. This interpreter's going to be asleep here in like 5 minutes. I feel it.
Okay, man. So here's what I was thinking, and you tell me if this is going to be too tight. That I would allow basically a half an hour window is my thought of him being able to be at the address, get the kids, and go. Is that too tight a time frame, or?
Pick up the kids and pick the house, get elsewhere.
Isn't that what he would be doing? I thought that's what you told me.
She wants him to stay at the house?
Okay, and then he's at the house until time to go to school. Okay, I don't know. I heard that differently. I thought he was coming there to get the kids, to pick them up, to then
at this
go
point,
someplace else. Gotcha.
The bond conditions are almost useless at this point. He stays at the house.
So if you're out at 4:30, kids go to school at 8:30. They're a carpenter. Okay, so
I think the judge is trying to preserve the conditions as much as he can while still structuring the
either
ability.
side have any? I had given that half hour because I thought he was picking them up, taking them someplace, and then getting them to school. But when I look at the address and they're at Carpenter, that makes no sense, right? So, is there going to be a problem with having a window of time that the defendant could be at the address for the purposes of childcare to then take the kids to school? So
Are we looking underneath the bed? Is he leaning against
okay,
the
so
bed?
how's that exchange? Mm. You would go to what house? The Hawks? But that's where you are.
Maybe Jason can bring the child to the school.
Yeah, dear goodness. And let me do this. Let me pass the matter just a bit if you've got time. Let me get through some things here, and then let's try to the details, because he would be there at that point. But let me ask this. At the point that the other two go to school, what happens to the 2-year-old?
That's fair. He's always been asking.
So even under the arrangement that you had, he was with Dad. And where's Dad take the 2-year-old?
My understanding, he has been staying with his mother, and that's usually where you take your 2-year-old.
Okay. So what happens is, or what you would see happening, but somehow and or another, the 2-year-old has to be returned to your care for the evening. How far Your mom's down in Nipsey.
Yeah.
Yeah.
We work 2 separate shifts. So when she comes at 3:30, I work at 6. I can leave when she comes and go to work. And when I get off of work at 2:30, she leaves at 4:30.
Hold on, you gotta back that up for me. You went fast. It makes sense to you, but I gotta follow in my head.
So
She works you work 4:32.
What's that yellow
Okay.
and black logo underneath the bed?
Got it.
What does that say?
6 p.m.
It's upside down.
30 a.m. So we never had childcare packs because we work 2 separate
shifts.
I think it said shifts. Shifts.
So as you're coming off of work, the idea would be that you would then arrive at some point to then take care of the children as she leaves. Then she's going to pick child up, the 2 of the children from school, right? And then somehow or
this
another,
whole hour's
then
docket
this
is getting
2-year-old.
pushed to the next hour.
That's the way it always was with me. The 2-year-old always does the problem.
I have to pick the children up from school and return them home.
I'm guessing there's
Say
some
again.
sort of domestic violence allegation here.
Sometimes they work 10-hour shifts. She gets home.
She gets home, but if she gets, okay, so at the residence and then go, because you've got to get yourself ready to get to work. Got it. So let me ask this, because it isn't complicated enough. School's going to end soon. What then? Because
I don't get my care like you get until she comes.
okay, so
I think Anastasia and the interpreter are passing subliminal messages back and forth.
Okay. Here's what I'm going to do. Because really, yeah, we're operating with the school schedule, but we're really operating with the work schedule on childcare. So I'm going to keep, and counsel for defendant will draft an order satisfactory to the people. And then if you guys get into a dispute as to language, I'll get with the language. Two periods of time, because that'll take you through the summer. Or if this case goes beyond that, it will be able to operate this way. But it's really going to be operating off of the work shifts, so that there's a window in the morning that they can have contact at the Hawk Street address. And then also a window, I guess it's the afternoon, that also that contact can occur. Everybody follow me? So I'm just looking at 2 windows of time where that exchange can happen, and then they can also get themselves to work. All right. And it won't matter in a certain respect whether then the children are in school or not. I mean, Carpenter's right around the corner anyway. So it won't matter, because he decides to pick the children up and bring them there, as long as he does that within the window, then fine. Make some sense? Okay. Since you brought this to me, and made my head hurt. You, counsel for defendant will prepare the order, and like I said, I'll work on that. Ma'am, will that, you think, work for you? Not a problem. All right, thank you.
Next. Let's see if we get our interpreter.
Exactly 2 cases.
Hours.
Or calls the case of people versus Messiah Wadlington. Also, just on that last matter, on that order, I want that third party consensual, I want that, delete that language.
Yes, Your Honor.
Okay, because I don't know what that means, and nobody does, it seems. All right, go ahead.
This is probably better to have the papers. Wellington, Messiah Wellington.
Thank you. All right, what are we doing?
Your Honor, this is the first pre-trial matter. We are respectfully requesting a brief adjournment in order to review discovery response.
Matters adjourned May 20th, 2024.
Oh, Anastasia.
1 p.m.
Again.
Bond continued.
Thank you, Your Honor.
Okay. Last time I said bond continued, that was a half an hour later. Court does call the case, People versus Anthony Randolph.
And people that there's supposed to defenders and Mr. Randolph.
Is he in a hammock?
Anthony Randolph?
It looks like a hammock hanging on the wall behind him.
Hearing, he is compliant with the terms of his probation.
What?
However, Mr. Randolph does have an outstanding bench warrant for an old probation case that got sent to collections. That case number, it is a part of ours, Judge. He failed to appear for a show cause hearing and a bench warrant was issued.
What case?
The case number is 21F4-0060. He owes a balance of $1,290.
How much?
$1,290. I would like to ask the court to address the warrant in that case and maybe set more review hearings to make sure he's paying on that along with this case.
No objection to that, Your Honor. I did inform him about the bench warrant. I was going to provide him information on recall that. I apologize, I did not get that over to you, Mr. Randall. If the court has.
I have to file.
Oh, okay.
So, Mr. Randolph,
Yes.
how did he make arrangements with collection or no?
I believe that he did, and then this case came along. He has been paying, so he's completely compliant with his treatment, his TV program.
On the current case.
Correct. And so payments haven't been being made to the other, and I believe he showed cause in front of you, and he did not adhere to that. But he's.
That's true. He did not in February. Yeah.
So I'm not sure if there was something in there with that, but I did speak with Mr. Randolph about it, and he knows that he needs to be making payments on both of his cases.
All right, so here's what I'll do. In case ending in 843, I will continue all terms as previously ordered, set the next review hearing for August 5th, 2024 at 1 p.m. That takes care of that. Now, Mr. Randolph, on your other matter that you owe the money on, how were you intending on trying to get that paid?
I wasn't sure how to be able to pay that. I wasn't aware that I was still owing money on that case until about January.
What have you done since January?
We could come up with a payment plan. I guess I could probably do $50 or $60 a month, but I'm already paying $88 in probation fees on top of all my other bills.
Hold on. That's how you get in trouble. You start talking too fast, like I can't listen. When you listen to me, then we're good, right?
Yes, sir.
Okay. So how much are you paying on the other case? 88?
Yes, sure. And then he also has his domestic violence advice that he's got to pay for every week as well.
Okay. Okay, so here's what I'm gonna do. And you're working right now though, right?
Yes.
Okay. Mr. Randolph, how are things been going?
Things have been going fairly well. I've been trying to deal with getting my son's issues and attitude under control, but other than that, things have been going fairly well in life.
Your son has an attitude problem?
Oh yeah, sins of the father, right?
I don't say sins of the father. I'm just saying that apple probably doesn't fall that far from the tree. So you probably ought to recognize it when you see it.
Oh, I absolutely do.
Doesn't look pretty, does it?
No, I have a newfound respect for my parents in the court at this point.
Well, I'll tell you what. For me, I just had to wait for you to grow up a little bit. And then things got a little bit better when you started realizing. So maybe that's the way it's going to be for your son. Let's hope not. And let's hope the agony isn't there with that. All right. Here's what I'm going to do. We set that other August 5th.
Yes, Your Honor.
Okay. You're paying all of that other stuff. Figure out how you can get this done. I'm going to give you a bit of a break here. I'm going to cancel your bench warrant, and I'm going to set that at a PR, and then I'm just going to indicate no payments needed for now.
Wow.
All right, and I'll just set this for a show cause on August 5th, the same time as the other one. Okay. So you try to figure out financially how you could do it, and then be able to tell me how you can get some of this, start paying on some of this. Fair enough?
That works for me, Your Honor. Thank you.
Thank you. You didn't think, with all the stuff we went through, you didn't think I'd ever do anything nice for you.
Well, I had to admit the thought occurred that it might not happen.
Well, as long as you're doing the right thing, we don't have a problem. And I think you know that. It's when you start doing the stuff you're not supposed to be doing.
No, I understand that, Your Honor, and I appreciate your leniency with the payments.
All right. You take care. We'll see you in August.
All right. I'll see you in August. Thank you.
Thank you. Court does call the case. People versus Conjule Burton.
And then on behalf of the people, Assistant Public Defender Natalie Pickles, Mr. Burton, whose appearance has been waived. Please declare on behalf of probation, Your Honor, Mr. Burton is scheduled for the court for a review hearing. He is compliant with all terms ordered by the court. Probation is recommending that all terms continue as previously ordered, with the next review hearing being set August 5th, 2024 at 1 p.m. So, judges.
So
That was just a check-in.
Court calls the case. People versus Edward LaRue.
I think our interpreter and Anastasia have formed a bond.
LaRue was scheduled for a review hearing before the court. He is compliant with recommending all conditions continue as previously ordered with the next review hearing at August 5th, 2024.
So ordered. Court does call the case. People versus DeJuan Olive.
And on behalf of the people, Assistant Public Defender Natalie Pickles, Mr. Allen. Please declare on behalf of probation. Your Honor, Mr. Allen was scheduled before the court for a review hearing. He is compliant with all terms ordered. Probation is recommending that all conditions continue as previously ordered.
So ordered. Court does call the case. People versus Stephen Robertson.
Now, is it on behalf of the people?
Teresa Claire on behalf of probation, Your Honor, Mr. Robertson is scheduled for the court for a review hearing. He is compliant with all terms stated by the court and the hearing. Probation is recommending that officers continue with the next review hearing on August 5th, 2024.
Hearing no objection, so ordered. Court does call the case of the people versus Myron Davis.
Teresa Claire on behalf of probation, Your Honor, Mr. Davis is scheduled before the court for a review hearing. He is compliant with all terms ordered by the court, and I give Davis a hearing. Probation is recommending that officers continue with a line of review hearing being set August 5th, 2024.
Hearing no objection, so ordered. Court calls the case people versus Jason Gerlach.
And then on behalf of the people, there's this public defender one hearing on behalf of Mr. Darrell.
Oh, you decided to do something. No good.
Teresa Claire on behalf of probation, Your Honor, Mr. Darrell is scheduled before the court for a review hearing.
Just all the paper shuffling is
Recommending all conditions continue with the next review hearing being set August 5th, 2024.
So ordered.
Since the last public one, Mr. Burgess is not here. We did send him on Zoom and then he dropped out.
The defendant.
And it's attorney.
and his attorney.
So Carter's here. We don't have Burgess.
The defendant is present.
Yes.
Ooh, defendant's present, but attorney is not?
Well, we're going to have to go down and back up.
Okay.
Back down.
Kicked us off again. Kicked us off. So we're going to have to go down and come back up. Know what they're doing off air, but all right. You see a zebra. There's a zebra right here. I know they have something they do off the air. I want to know what's happening with Anastasia. Are they back up yet? Live now? Nope. We'll see. Might be back. I want to see what's up with Anastasia before we take a lunch break. For those that missed out, yes, we have Darrell Brooks in the title of the thumbnail or the live stream today, but Darrell Brooks, last minute, accepted a plea deal. Pled guilty to 2 lesser charges and will be sentenced in August for that. Either way, it won't change where he lives now because he's in custody and will be for the rest of his life. So go eat your ice cream. We're going to see that. We're going to get some ice cream. Let's see. Yep, I think it's time for ice cream now. I don't know. We might have to come back and see if we can find out what happened to our Swahili interpreter and Anastasia, who I guess the tour of the building she's in is over now. So let's see. Matthew Harris, congratulations on the anniversary of your being a lawyer and your business. That is awesome. Little party for you. There you go. Oh, that's the wrong one. I mean, it's happy birthday for Matthew Harris, but we're gonna use this one because it's time for a break. There we go. Yes, I'm gonna have some. What is it? It's cookies and cream mixed with chocolate chip cookie dough. Cookie Two-Step is the name of it. Fantastic ice cream. They didn't kick us off. They just kicked the live off because they had to do something either using the computers or off air. So I don't know. I'm debating. I'm not sure if Karen Reed trial is far enough ahead, being in week 2, that we can start catching up. I don't want to catch all the way up, though. That's the point. I don't want to be caught up. We want to do after the fact where we address that. We might do it in the afternoons, too. So it doesn't conflict with people who want to stay up to the minute with watching it. All right, Reverend Beasy, there you go. Tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again. As always, carry emotional support, Zebra. There we go. Are you going to dance while eating it? You always dance while eating ice cream. That's how you work off the calories. And chocolate chip. Good choice as well. I like that. That's a good one. Matthew said, I'm back. Now's a good time probably to go over to Matthew Harris's channel during lunch and pop over there. Just, take a little listen. Maybe take the quiz, the law quiz. So we'll do that just in time to say bye. All right. Have a great lunch. We're going to, we'll be back. We'll see if we can find the rest of that Judge Simpson happenings when we get back from this. You guys have a great lunch. We'll see you on the flip side. Bye-bye.
Because he's the guy.